Welcome back to the Orange County Board of County Commission meeting of March the 10th, 2026. We are now in the afternoon portion of our meeting. As we begin this afternoon, we're going to start with our land use issues, and we're going to begin with our planning and zoning recommendations, and Ms. Lakin O'Hara is going to frame those issues. And with that, you're recognized.
Good afternoon, Mayor and Commissioners. On February 5th, 2026, the Board of Zoning Adjustment heard 8 cases. 7 cases were recommended for approval. 1 case was recommended for denial. The BZA appeal deadline was on Friday, February 20th, and 1 appeal was received for case VA 2602087, Ugraj Bahari. The Zoning Division will be requesting that this case be scheduled for a separate public hearing. So with the exception of case VA 2602087, which was appealed, we request that the BZC accept the BZA recommended action and findings.
And with that, do we have a motion for approval? All right. Motion by Commissioner Uribe, second by Commissioner Scott. All in favor, let it be known by saying aye.
Aye.
Opposed, no. Motion passes, and it is unanimous. With that, then we'll move to the next item on our agenda. I'm going to call on Mr. Jason Sorensen, our Chief Planner from the Planning Division, to present our planning and zoning recommendations.
All right, thank you, Mayor, and good afternoon, Commissioners. On February 19th, 2026, the Planning and Zoning Commission considered 5 conventional rezoning requests, all of which were recommended for approval. We have not received any appeals. However, we have received a request from District 5 Commissioner Simrad to pull item RZ 2601038, located at 526 and 538 Shepherd Road, for a separate public hearing. Therefore, the action requested is to approve the February 19th Planning and Zoning Commission recommendations with the exception of RZ 2601038, and staff is available for any questions.
All right. With that, do we have a motion for approval?
Second, Gomez.
Okay, motion by Commissioner Scott, second by Commissioner Gomez. All in favor, let it be known by saying aye.
Aye.
Opposed, no. Motion passes, and it is unanimous. All right, we're going to move to the next item on our agenda for this afternoon, and this is item A1, the Municipal Service Benefit Units, MSBUs. We'll open the public hearing on this item, and we're going to have Ms. Ann Curtis, our MSTU supervisor, come forward, and she'll be framing that item. With that, you're recognized.
Good afternoon, Mayor Demings, County Commissioners. A1. This request is from a developer to establish the Avalon Woods MSBU for street lighting and retention pond maintenance, which consists of 182 lots. The street lighting assessment will be $201 per lot for operational expenses and administrative fees. The retention pond maintenance assessment will be $78 for operational expenses and administrative fees. This subdivision area is located in District 1. These establishing MSBUs for street lighting and retention pond maintenance will be effective November 1st, 2026, if approved today.
All right, with that, this is an administrative item. Do we have members of the public present who wish to be heard on this item?
We have no speakers for this item, Mayor.
All right, then we'll close the public hearing. We'll go to the District Commissioner. Commissioner Wilson, do you have a potential motion?
Yes, I'd like to move the requested action.
All right, we have a motion and a second. All in favor, let it be known by saying aye.
Aye.
Opposed, no. Motion passes, and it is unanimous. With that, we'll move to the next MSTU, and we'll open the public hearing on A2. And with that, Ms. Curtis, you're recognized.
A2. This request is from a developer to establish the Hamlin Meadows at Hamlin MSBU for street lighting, which consists of 165 lots. The street lighting assessment will be $121 per lot for operational expenses and administrative fees. This subdivision area is located in District 1. This establishing MSBU for street lighting will be effective November 1st, 2026, if approved today.
All right, we'll open the public hearing on this item. Do we have members of the public present who wish to be heard?
We have no speakers for this item, Mayor.
All right, then we'll close the public hearing. We'll go to the District Commissioner, Commissioner Wilson.
I'd like to move the requested action.
Second, Uribe.
All right, the second is Commissioner Uribe. All in favor, let it be known by saying aye.
Aye.
Opposed, no. Motion passes, and it is unanimous. We'll move to item A3. We'll open the public hearing on this item as well. And with that, Ms. Curtis, you're recognized.
A3, this request is from a developer to amend the Harvest at Ovation area, MSBU, for street lighting and retention pond maintenance to include Harvest at Ovation Phase 2 and Harvest at Ovation Phase 3 subdivisions. The street lighting assessment will be $164 per lot for operational expenses and administrative fees. The retention pond maintenance assessment will be $78 for operational expenses and administrative fees. This subdivision area is located in District 1. These amending MSBU's for street lighting and retention pond maintenance will be effective November 1st, 2026, if approved today.
All right, thank you, Ms. Curtis. Do we have members of the public present who wish to be heard on this item?
We have no speakers for this item, Mayor.
All right, then we'll close the public hearing. We'll go to the district commissioner, Commissioner Wilson.
I was going to say it's D1 day, but we're just renewing a bunch of these, so at least this one. I move for the requested action.
Second, Scott.
All right, we have a motion and a second. All in favor, let it be known by saying aye.
Aye.
Opposed, no. Motion passes, and it is unanimous. And we're going to A4 now on the agenda. We'll open the public hearing on this item. Ms. Curtis, you're recognized.
A4, this request is from the Developer and Environmental Protection Division to amend the Lake Roberts, Lake Reeves MSBU for general lake cleaning, water quality improvement, maintenance, and aquatic plant control to include 6 lots from Watercrest at Windermere subdivision. The lakefront access assessment will be $200 per lot for operational expenses and administrative fees. This subdivision area is located in District 1. This amending MSBU for lake maintenance will be effective November 1st, 2026, if approved today.
All right, thank you. Are there members of the public present who wish to be heard on this item?
We have no speakers for this item, Mayor.
All right, we'll close the public hearing. Commissioner Wilson again.
I'll move for the requested action.
Second, Uribe.
All right, we have a motion and a second. All in favor, let it be known by saying aye.
Aye.
Opposed, no. Motion passes, and it is unanimous. We'll move to item A5. A5, and Ms. Curtis will open the public hearing on this item, and you're recognized.
A5, this request is from a developer to amend the Lakesar at Ovation area for street lighting and retention pond maintenance to include Lakesar at Ovation Phase 1B, which consists of 74 lots. The street lighting assessment will be $270 per lot for operational expenses and administrative fees. The
All right, with that,
The retention pond assessment will be $78 for operational expenses and administrative fees. This subdivision area is located in District 1. These amending MSBU's for street lighting and retention pond maintenance will be effective November 1st, 2026, if approved today.
all right, now you're finished. All right. With that, do we have members of the public who wish to be heard on this item?
We have no speakers registered
All
for this
right,
item,
then
Mayor.
we'll close the public hearing. Commissioner Wilson.
Move the requested action.
Second, Scott.
All right, we have a motion and a second. All in favor, let it be known by saying aye.
Aye.
Opposed, no. Motion passes, and it is unanimous. We're going to move to item A6. We'll open the public hearing on this item. Ms. Curtis.
A6, this request is from a developer to amend the Lake Viewpoint at Horizon West area, Ravenna area, and Mazzano for street lighting. This amendment will add 1 lot, shops at Lakeview. The street lighting assessment will be $223.85 per lot for operational expenses and administrative fees. This subdivision or this commercial lot is located in District 1. This amending MSBU for street lighting will be effective November 1st, 2026, if approved today.
All right, thank you, Ms. Curtis. Are there members of the public present who wish to be heard on this item?
We have no speakers for this item, Mayor.
All right, then we'll close the public hearing, and we'll go to Commissioner Wilson.
Move the requested action.
Second, Uribe.
All right, we have a motion and a second. All in favor, let it be known by saying aye.
Aye.
Opposed, no. Motion passes, and it is unanimous. And we're going to give Ms. Curtis a break now. We're going to move to item B7, petition to vacate. We'll open the public hearing on this item, and Ms. Susan Usack, our Deputy Director of Public Works, will be framing this item. With that, you're recognized.
Thank you, Mayor. This is a petition to vacate PTV 25-06-016 from Ryan Joseph Fisher. The petitioner requests that Orange County vacate a 60-foot wide right-of-way known as Lake Pleasant Court that lies between his two residential lots located within the Lake Pleasant subdivision containing approximately 0.51 acres. The property lies south of Atlantis Drive and east of South Apopka Boulevard. The real estate management, environmental protection, engineering, transportation planning, and roads and drainage divisions have no objection to the request. All utility providers have also provided letters of no objection. Approval of this request will have no adverse effect on the county, and staff has no objection to this request. However, this petition is to vacate This petition to vacate was subject to a 60-foot wide right-of-way dedication that provides legal access, construction, operation, and maintenance of roadway facilities. As such, the morning BCC consent item agenda E6 was pulled to run concurrently with this PTV to ensure that the condition would be met. Consent agenda item E6 is associated with the approval of the warranty deed from Mr. Fisher to Orange County and the authorization to record instrument related to the petition to vacate 25-06-016 Lake Pleasant Court. Our requested action is approval of the pulled morning BCC consent agenda item E6 and PTV 25-06-016. This parcel is located in District 2, and I'm here to answer any questions.
All right, so we're hearing B7 along with E6 from this morning. Is the applicant on this item present? Would you like to make any comments? Okay, he's going to waive on making any comments. Are there members of the public present who wish to be heard on these items?
We have no speakers for this item, Mayor.
All right. Then we'll close the public hearing. Commissioner Moore cannot be here this afternoon. I'll move the requested action.
Second, Gomez.
Second by Commissioner Gomez-Cordero. All in favor, let it be known by saying aye.
Aye.
Opposed, no. Motion passes, and it is unanimous. With that, we're going to move now to item B8. We'll open the public hearing on this item, also a petition to vacate. And again, Ms. Susan Usack, our Deputy Director of Public Works, will be framing this item.
This is a petition to vacate PTV 25-08-020 from Mary Mercedes Gonzalez. The petition requests that Orange County vacate a 2-foot wide portion of a 10-foot wide utility easement located along the south property line and a 0.5-foot wide portion of a 5-foot wide utility easement located along the east property line of her residential lot located within the Deer Run South subdivision containing approximately 36 square feet. The property lies south of Gulfway Boulevard and east of Woodbury Road. The Real Estate Management and Environmental Protection Divisions have no objection to the request. All utility providers have also provided letters of no objection. Approval of this request will have no adverse effect on Orange County, and staff has no objection to this request. Our requested action is approval of PTV 25-08-020. The parcel is located in District 4, and I'm here to answer any questions.
All right, thank you. Is the applicant on this item present? If so, would you like to make any comments? She's saying no. So with that, do we have members of the public present who wish to be heard on this item?
We have no speakers for this item, Mayor.
All right. And then we'll close the public hearing portion. We'll go to the District Commissioner, Commissioner Gomez-Cordero.
Motion for approval?
Second, Scott. All right, we have a motion and a second. All in favor, let it be known by saying aye.
Aye.
Opposed, no. Motion passes, and it is unanimous. We'll move to item B9. We'll open the public hearing on this item, and Ms. Susan Usack, our Deputy Director, again from Public Works, will frame this item.
This is a petition to vacate PTV-24-08-030 from Miro and Donnie Jayla Lucanen. The petition requests that Orange County vacate a 60-foot wide portion of a 350-foot wide drainage easement, less out 10 feet on the west and east side, that lies along the north side of their residential lot located within the Magnolia Springs subdivision containing approximately 0.21 acres. The property lies north of White Road and east of South Clark Road. Public Works recommends denial of the petition to vacate of the drainage easement. The existing easement encircles the pond that receives runoff from the adjacent subdivisions and portions of White Road. This property is located within a landlocked basin that relies on overland percolation and this pond for stormwater management. The drainage easement provides a natural buffer that contributes additional stormwater storage capacity, which is critical to the overall function of the stormwater management system in that area. Our requested action is denial of PTV-24-08-030. This parcel is located in District 2, and I'm here to answer any questions.
All right, thank you. Is the applicant on this item present? If so, would you like to make any comments? Okay, he's waving also, or would you like to make comments? Okay, you can come to the mic. And as you're coming, just remember to give us your name and address for the record, if you don't mind.
My name is Miro Lučanin. The property in question is 9,000 Montevelo Court. Zip code is 32818. I'm not going to try to take too much of your time. I did want to appeal and ask at least a further explanation as to why. Aerial picture of what we've seen as far as my property goes, I feel like and believe that is very misleading. The area that they're talking about, at the end of it, right at the edge of the 60 feet that we've asked of, there's another 20 feet that is a 15% grade going down, and then there's a hill that's at 45 degrees that has another 110 feet where there's no water. We have a next door neighbor who's a general contractor. He's had a couple of his friends and associates come out and take a look at it just to make sure before we even applied for anything, just to see if it is doable. There's also 2 more retention ponds that are attached to the main retention pond. In order for water to reach anywhere near even just the slope of coming down, the neighboring houses would have to be underwater. So that was a big reason as to why we came out to ask, because right now, out of the 1.93 acres that we own, we can essentially only use 0.3 of an acre. So we were hoping to work with the city, and as far as the engineers go, I have complete respect to what their job is, but I would like at least somebody to come out and take a look at the property, because I genuinely do believe we checked, there's no utilities running. We've had some work done a couple of years ago because the actual runoff from the street collapsed. That's all of the city, I apologize, all the city utilities left or right of our property. So the area that we're asking for has nothing underneath it. There's no pipes, there's no electricity, there's nothing running. And even if the 60 feet was allowed, there would still be over 130 feet of property that's at a steep grade coming down that would allow any kind of water falling down. And one of the engineers that we have come out and take a look at it, we are literally talking if in the next year we had what we've had in the past 17 years of rainfall, it would still not come even close to filling up the amount of pond that is allowed to be out there. And like I said, looking at the picture, I completely understood even when we got in denial because it's extremely misleading. Thank you.
All right, and you can have a seat, stand by for a moment. Do we have members of the public present who wish to be heard on this item?
We have no speakers for this item, Mayor.
All right. So we'll close the public hearing portion. Commissioner Moore, again, Third District could not be here. I'll open up for questions by members of the board. Commissioner Uribe.
So if I could, Susan, I'm assuming he's the applicant that is going to be getting the denial, correct? Can you share a little bit more why the staff recommended denial?
So on page 3 of the presentation, it shows like the overall basin that discharges to that area. This site is a landlocked basin, so any additional storage that we vacate, we don't want to put a burdensome property around the surrounding ponds at risk.
Yeah, no, okay.
Is there an aerial?
Yeah, maybe we could show an aerial.
It's on the PowerPoint presentation, slide 3.
Okay.
It has the outline of the map.
Can we go back to slide 3 since he was referencing that? So
that one. So the red outline is the basin that discharges to that pond. So then there's overland flow that it perks through the ground. In addition to that, all the stormwater runoff goes to that pond. So Correct.
I know, enough said.
Okay.
I can make a motion.
Okay. Any
satisfied.
other questions? No?
I'm ready, I can make a motion.
Okay. All right. If there are no further questions, then
Mayor,
I'll-
I did have
Commissioner
one
Scott.
question, my apologies. If you could approach? Yes, sir.
Can you speak into the mic a little more, Commissioner?
Yeah, I got you.
Yeah.
Sir, is there, if you were to have additional time, do you think you can work with staff to get a recommendation of approval, or no?
Absolutely, sir. Absolutely. And when we requested 60 feet, I'll be honest with you, we're completely new to this process. We're brand-new homeowners. We just bought our house 5 years ago, so we're not aware of all the procedural things that need to happen. When we spoke to the gentleman initially, we asked for 60 feet, and we reduced it by 10 feet to both sides, just as a recommendation. But we did let them know if they wanted to shorten it, even if it was something between 20 and 40 feet that they would approve, we would have no issue. Or if they could just tell us what we could do, it's without taking up too much of your time. It's a multifamily dwelling. My parents live with me. My grandfather lives with me. We take care of everybody. In order to build up a house so we can take care of everybody that's involved, we just needed a little bit of extra space. Because is there any chance just to take a look at the picture again of the closer pull up? So even now, this is not even closer to water is, and there's another lake that connects to it, that it's about 2 miles from us, that is almost completely dried out over the past decade or so. Okay. So we are not sticking to the 60 feet, nor are we demanding anything. We just wanted to work with the city and see if there's any possibility to extend.
So I understand you correctly, you basically have an extended family. You are all living in one home, right?
Yes, sir.
Okay.
Yes, sir.
Okay. All right, I just wanted to get that clarification. Thank you.
Yes, sir. My pleasure.
He'd be working with the county, not the city, correct?
Yes.
Okay, just want to make sure you kept saying, I didn't know, I just want to make sure I understand.
Yes, sir. Yeah, nobody has come out. We haven't had the chance to walk the property with anybody to talk or show them what we were actually talking about. Like I said initially, when we looked at the pictures and everything, it made complete sense that they would say no. But I firmly do believe if the engineers had a chance to come out and take a look at it, especially because we had other professionals come out, we just cannot afford to do the survey ourselves because we are talking about tens of thousands of dollars to come out and present a legal case in front of this. So we were just appealing to the city to see if we could have somebody that could partner with us and work with us and see if there's anything that could be done.
Okay.
All
Susan,
right. Commissioner Wilson has a question. You still
I was
have?
going to ask one
Okay.
question to Susan.
Okay.
I'm good, sir. You good?
Yes, sir.
Susan, let's just say we move with their requested action as staff. Could they then come back with a revised plan or I guess?
We would still deny the thing because it's additional storage capacity. As the water stages up, we want to make sure that the abutting property owners surrounding this whole pond and those beyond is protected. So any storage capacity that's getting diminished from the petition to vacate is not a good recommendation.
So are there no options or limited options for him to get approval from staff
We would not recommend it.
in any fashion?
We want them to not build on the easement for drainage, so.
Okay, I'm good. Thank you.
Commissioner Wilson.
I was going to say, I think we have to make sure that we're being super clear about, I greatly empathize with what sounds like a difficult set of circumstances for you all, but we are in a historic drought right now in Central Florida. So it's hard to imagine in some of these closed basins what we're talking about when that storage capacity issue happens. But should we need that additional capacity, I promise you, you're going to be happy that you didn't put a multifamily building there, because then you would have elderly people getting rescued from post-hurricane flooding. And we've had that across the county before we had the type of engineering standards that we have and the ability that we have today to see the possibility in the event of needing that additional capacity. So I just want to make sure that you know this isn't a punitive action, it's a protective one.
Yes, if I just may.
No, it was a statement. It wasn't a question. I just wanted to make sure we were being clear about when we rely on the engineering standards and the engineer. It's not a debate. It's looking at a slope. It's looking at the capacity and where the water is draining in a whole area. So unless there's any other questions, Mayor, I would I'd be willing to make a motion.
Right.
I'd make a motion for denial.
Second,
All right.
Uribe.
We have a motion for denial by Commissioner Wilson, second by Commissioner Uribe. No further question. All in favor, let it be known by saying aye.
Aye.
Opposed, no. Motion passes, and it is unanimous. So unfortunately, it has been denied. All right, we'll move to item C10. At this time, we'll open the public hearing on this item. Mr. Tim Hull, our Environmental Programs Administrator, is going to come forward and frame this item. With that, Mr. Hull, you're recognized.
Thank you. Good afternoon, Mayor and Commissioners. Today I'm presenting Shoreline Alteration Dredge and Fill Permit Application number SADF 25-10-029 for the applicants Richard and Lisa Wilson, and this is for a replacement seawall. Here's a location map. The property is located at 9186 Bay Point Drive in Orlando, 32819 on the shoreline of Lake Tibbet-Butler. Here is an aerial photo with the subject property outlined in yellow. And here's a couple photos of existing conditions. This wall was originally permitted as a retaining wall back in 1994. And currently, you can tell a little bit that the wood is starting to deteriorate and it's in poor condition and in need of replacement. You'll see that there's a number of cypress trees as well. And because of those trees up against the wall, they're actually going to install the new wall behind the existing and then remove the old one after that installation is done. Here's the site plan with the proposed replacement wall shown in red. Both of the neighboring properties have seawalls, and there are also other seawalls present on Lake Tibbet-Butler. The wall will be approximately 91 feet long and have 8-foot returns on both sides. Here's a cross-section of the seawall. Based on prior board direction, native plantings and riprap were normally required, and the applicants are proposing to install both riprap and native plantings in front of the wall. And the considerations on this project, it was reviewed in accordance with Chapter 33, Article 4, Section 33-129, and the reviewed criteria and conditions of issuance therein. Notification of this public hearing was sent to property owners within 500 feet, and EPD received no objections. Our finding is pursuant to County Code, Chapter 33, Article 4. EPD has evaluated the proposed SADF permit application and required documents, and has made a finding that the request is consistent with Section 33-129. And our action requested is acceptance of the findings and recommendation of the EPD staff and approval of shoreline alteration dredge and fill permit SADF 25-10-029 for a request for shoreline alteration dredge and fill permit for Richard and Lisa Wilson, subject to the conditions listed in the staff report. This is in District 1, and that concludes my presentation. Thank you.
All right, thank you. Is the applicant or a representative of the applicant present? Don't see anyone. All right. Do we have members of the public present who wish to be heard on this item?
We have no speakers for this item, Mayor.
All right, then we'll close the public hearing portion, and we'll go to the District Commissioner, Commissioner Wilson, for a potential motion.
Yes, I'll move the requested action.
Second, Uribe.
All right, the second is Commissioner Uribe. All in favor, let it be known by saying aye.
Aye.
Opposed, no. Motion passes, and it is unanimous. All right, we'll move to the next item, and this is item D11. We'll open the public hearing on this item, and Ms. Lakin O'Hara is coming back. Our Chief Planner from the Zoning Division will be framing this item.
Yes, good afternoon again. This is case VA 25-12-073, and the applicant is is Rebecca Hammock. This is a board called item. This is in the RCE, Rural Country Estates Zoning District, and it has a future land use of rural settlement 1-to-1. That's the West Windermere Rural Settlement. And just to note, the 1-to-1 means one dwelling unit per 1 acre. This is currently an unaddressed property, but it's located on the west side of Windermere Road and north of McKinnon Road, and it's 0.73 acres, and it is located in District 1. The District Commissioner has been briefed on this item. The request is a variance in the RCE zoning district to allow a minimum lot area of 0.73 acres in lieu of 1 acre. Here's the general location map. We have this property, and then the next case actually is the property directly to the south of it. So just for reference there, those are contiguously owned. Then we have the zoning map, as you can see, is primarily RCE zoning around this area. We have some A1 and some of the city of Windermere, all residential properties up to the north and then to the east. And then the aerial map, you can see that this is unaddressed because it's undeveloped currently. The site plan here is just for reference, as this is just for the variance request itself is for lot area, so it's that 0.73 acres. They're bounded in red, but as you can see, it could be developed with a single-family home meeting setbacks. Just some site photos of that vacant property. This is facing west towards the front, facing north, and then southwest, and then facing northwest at the corner. You can see there's that adjoining parcel, and then the subject property is the vacant one. Just to give you some history, in February of 1992, there was a letter from Orange County Zoning Department confirming the process for obtaining a substandard lot of record determination and then a vested rights for consistency certificate. This letter was just informational in nature. In March, there was then a follow-up letter confirming that the lot was a substandard lot of record, using that substandard parcel of record language used at that time, and they directed the applicant to the planning department to identify consistency with the comprehensive plan. A lot of record per the zoning code is a parcel of land with a deed recorded on or before October 7th, 1957. And I make that kind of differentiation because a lot of record per the comprehensive plan is different. It's based on the date of the comprehensive plan. So in March then of 1992, the planning department issued that consistency of vested rights application for the construction of one single family residence on the subject property. And that letter then references section 353D10, which is the concurrency in vested rights for parcels of record in rural settlements. That section talks about legally created lots that can be developed with a single family residence or structure, and they can be modified notwithstanding that future land use designation. It notes that multiple contiguous parcels in common ownership as of May 21st, 1991 shall be aggregated or deemed to be one parcel for the purposes of vested rights. It goes on to say that vested rights shall not exempt any project from other regulations. So that would be other land development code regulations or things like utilities, development engineering. In April of 1992, there was a response to a letter from the proposed property owner that was to the Orange County Planning Department. They had questions on the consistency vested rights application. So there were answers to those questions, basically about the ownership of the land in relation to the vested rights certificate, and they noted that that would still apply, and that if they aggregated the property following that it would still be considered a lot of record per the comprehensive plan. The comprehensive plan has had an aggregation requirement that says if you own two contiguous properties before the comprehensive plan came into effect, then you would need to aggregate those. But since this was individually owned at that time, it does not apply. So going into what all of that means, essentially we have two issues at play. One is that you have a future land use that requires 1 acre for every dwelling unit. Because this is not 1 acre, we then look to that concurrency vested rights certificate. That says for comprehensive plan, you're okay. You don't meet the minimum lot area, but you're a lot of record before the comp plan, so you're good. Then we look at the zoning, and the zoning requires 1 acre in the RCE district. So those just happen to be the same requirement. This is a 0.73 acre vacant lot, and so that's why we're here for the variance request. So two separate issues. One of them is already resolved through vested rights. We're just looking at the actual acreage in response to the RCE zoning district. The proposal is to erect a 2-story single-family home totaling 6,998 gross square feet, and it does comply with all of the zoning standards other than that minimum lot area. Zoning code has a requirement that adjoining lots under single ownership where one or more is substandard be combined to form a single conforming lot. So as I was noting earlier, that subject lot is under contiguous ownership with the lot to the south, and both of those lots are substandard in regards to lot area. Staff mailed a total of 71 notices to property owners in a 1,000-foot radius, and there was no comments in favor and then 1 comment in opposition. Going through the variance criteria, we have our 6 criteria here, and so then staff's recommendation was denial. As the variance request, there's no special conditions and circumstances. The request is self-created. There would not be a deprivation of rights. The variance is not the minimum possible. The purpose and intent of the code is not met, as the lot is under contiguous ownership and it can be combined to create a conforming lot. The BZA discussed the surrounding area and similarly sized properties and determined the vested rights letter was basis for granting approval of the variance request. The BZA recommended approval with 3 conditions. Those are these standard 3 conditions. So the requested action today is to deny the applicant's request or approve the applicant's request with conditions, and then just for your reference there, the request. That concludes staff's presentation.
All right, thank you. Is the applicant or a representative of the applicant present? If you all want to come forward and make any comments, now would be the time.
Good afternoon, Mayor and Commissioners. How are you? For the record, Rebecca Hammock. I'm with Pape Dawson, formerly Polis and Bennett. I'm here today with my client, Mike Flegel from Toll Brothers, who's the contract buyer, and I'm also here with the homeowner, Pamela Ranson. My business address is 2602 East Livingston Street, Orlando, Florida, 32803. So as staff stated, we are requesting a variance for lot size. So the required lot size is 1 acre and the existing lot is 0.73 acres. So the only variance we're requesting at this time is just for the lot area. So the existing lot size and configuration were established prior to 1957, prior to Orange County zoning. The property was zoned RCE, Rural Country or Country Estate District, on October 10th, 1966. And as staff stated, it did receive a vested right certificate, 92-34, which was issued in 1992. And as you can see from this map, our request is not incompatible with the existing development trend in the area. There are other lots that are less than 1 acre. And you can see our two variance requests are indicated in yellow. The subject lot is the one that's shown as 0.73. At this time, I would like to hand it over to Mike Flegel. He's going to go through a series of letters that Lakin mentioned and kind of describe the history regarding the parcel of record.
Hey, good afternoon, Commissioners. And again, Mike Flegel with Toll Brothers, 2966 Commerce Park Drive, Orlando, Florida, 32819. Toll Brothers, like Rebecca mentioned, is under contract with Ms. Ranson to purchase this property. And fundamentally here, where we have a respectful disagreement with staff is we think there's an entitlement here to build 2 homes on the 2 parcels owned by Ms. Ranson. And staff is asking us to combine those parcels and only be allowed to build 1 home. Lakin did a great job walking through those letters, and I appreciate her giving the background there. And I want to just add a little more context and highlight where we think there's a disagreement. So Lakin mentioned that in the staff analysis that this was not self-created and would not create a deprivation of rights. And there we respectfully disagree, and we disagree because of the letter history in 1992. So in 1992, as Lakin mentioned, there was some initial correspondence with Orange County, and that came from Jim Phillips, a familiar name from the Dr. Phillips family, who owned this parcel and was writing the county to determine whether or not a home could be built on this single 0.73 acre parcel, which we agree is underneath the required 1 acre. So initial correspondence, county acknowledged it in February 1992, asked for more information. March 6th, as Lakin mentioned, zoning approved this as a substandard lot of record. You can see there they say a single-family residence would be permitted on the property provided all other applicable zoning requirements are met. So that's the first kind of thumbs up from zoning. And then there's some additional correspondence, and we get, now she mentioned the vested rights approval under the comp plan from The Planning Department, this comes March 16th, 1992. You can see they write there, this property is entitled to a vested rights certificate to build one single-family residence. So this is the second affirmation from the county in 1992 that you can build on this land. And again, I would mention in 1992, to give a background on these two parcels, Ms. Ranson grew up in the parcel to the south, which is the case you'll hear next. She grew up in that home with her father in the 70s and 80s. In the early 90s, her father thought, you know, it would be great if Pam came and lived next door to me, and I bought a parcel to build a piece of property on. So we believe this correspondence was in relation to Mr. Smith, Pam's father, investigating whether or not he should purchase this property from the Phillips family. So again, that brings us to the third letter, which is in April 1st, 1992. And this letter sought clarification that, you know, even if we own the property to the south, if we buy this parcel, will we still be entitled to build a home on it? And the county responds that yes. Thus, you can see here in the bottom right of the slide, regardless of whether a prospective buyer owns adjacent land, the subject property may be purchased by them and a single family dwelling unit could be constructed. So the exact issue that we're talking about today, this idea of whether or not you need to aggregate these properties, this was contemplated by the county in April 1992 before Mr. Smith bought the parcel. And then he proceeded to purchase the parcel. You can see here, this is a general warranty deed dated September 3rd, 1992. So about 4 to 5 months after those letters were written, Mr. Smith bought the parcel from the Phillips family, from I think that's called Certifying Fruit Company. It's a great name. So again, we respectfully disagree with staff's assessment that this condition was self-created and it's not a deprivation of rights. I think these letters show that the county made 3 affirmative representations to Mr. Smith in 1992 that this was a buildable parcel. He didn't self-create this condition. He relied on the county's representations. And it would be a deprivation of rights, again, because he had affirmative assurances that this was a buildable parcel in 1992. So that's why we're asking for the variance, and that's why we think it's worth granting. And again, this just, if you want to take a look, this gives you the full timeline, 1992, starting in January. The correspondence started by April 1st. Again, there were 3 letters, the third one coming in April 1st from the county stating that this was a buildable parcel. And then September 3rd, Mr. Smith purchases that property based on assurances from the county. So I'll hand it back over to Rebecca here just to kind of go over the variance criteria. But again, this is a photo of the house we would like to build on this parcel. And I would just state that even though it's under an acre, this kind of fits the character of the area, and it has many homes like this on underneath 1 acre.
Thank you. So the first variance criteria, which we believe we do meet, is that there is a special condition circumstance that exists, and that is that the property received a vesting certificate in 1992. So it was vested under the comprehensive plan. So we understand that that is not the zoning code, and that is why we are asking for the variance from the zoning code. But we believe the overriding, what governs is the comprehensive plan. We also do not believe it was self-created, as the family did purchase the property relying on those letters that Mike went through. So there was considerable due diligence on their part before they purchased the property to make sure that it could be built as 2 separate parcels. Also, we believe that the variance would not confer any kind of special privilege. The vesting certificate allows 1 single-family home to be built. And as I explained earlier, there are other lots in the area that are under 1 acre. And we believe denying the variance would deprive the owner the rights granted under the vesting certificate. And it is the minimum possible variance. The request is limited to lot size only, and all other RCE zoning requirements will be met. So with that, as staff indicated, the Board of Zoning Adjustment did recommend approval of the variance, and we respectfully request your vote to approve. And that concludes our presentation, and we're happy to answer any questions.
All right, thank you. If you'll stand by for a moment. Do we have members of the public present who wish to be heard on this item?
We have no speakers for this item, Mayor.
All right. Then we'll close the public hearing and we'll go to members of the board for any particular questions. Commissioner Uribe.
I just like to have a point of clarity if I can, and I heard you. So this is just for two particular homes, because when you hear Toll Brothers, you guys are usually multi-family manufacturing. So I'm just trying to get a point of clarity. This seems to be more of an individual lot, and you guys are the builders?
That's correct. So these are two separate lots, and they're requesting variances. So the next case is also a variance request for the lot to the south, which already is built with a single-family home. So in this case, yes, it's just two individual homes.
So Toll Brothers is just a manufacturing of this particular project, correct? It's not that, because I'm sorry, but you guys are normally building multi-single-family home neighborhoods. I mean, you built one in mine when I first was elected, not me for me, but in my community when I was first elected. So I'm just trying to get a little point of clarity. It just seems to be an isolated situation. And I'll ask you in a moment, but if you could just share.
It is, that's correct, Commissioner Uribe. So this is fairly isolated. Toll Brothers, you're correct, builds about 300 homes per year throughout Central Florida. In approximately 15 different communities, many of those in Orange County. And this is a very limited part of our business where, in particular instances, we've identified these two lots to build infill lots on. So this particular stretch, I think, is the one spot in Orange County where we're actually building on individual lots.
Okay, and then if I can ask legal, so I actually have papers like this from back in the day on my property. So can you kind of give us some sort of, to me, it seems like nowadays we hear this thing, well, in the 80s and 90s, this is what happened. But then we're hitting now and what we're dealing with at this point where staff is denying or recommending denial or not agreeing. Can you share some legitimacy to this? It actually looked like my birth certificate from back in the day. So that was a letterhead that Orange County was using. We've come a long way. But if you could just share some insight for us on that.
Yeah, I don't think anything related to staff's review of the historic letters challenges their authenticity or what they state. I think the difference in opinion, which the applicant and staff both hit on, is the applicability of that aggregation requirement and the common ownership. And so that common ownership and aggregation requirement existed when those letters were written in the 90s. And the opinion that was given at that time was that because the common ownership did not exist, they both were substandard lots and they were vested from the comp plan to be able to be developed as single-family units. But both those the letters in the 90s and current code requires that two substandard lots that come under common ownership, which currently, I forget the applicant's, the daughter's last name, but currently it's common ownership under her. And so the position of staff is that the current zoning requirement is for them to be aggregated together.
So if they actually split it into two ownerships, it would completely.
So what the vesting does is it protected two substandard lots owned by two different individuals to be able to have the right to develop it for a single-family home. Zoning code then requires for common ownerships to be aggregated together. The thinking being in the 50s and the 90s, which are the important dates for determining common ownership under the zoning code and the comp plan, was for that very reason, was so that lots that were separated on paper but were commonly owned, it was clear that you were not entitled to multiple homes simply because you owned multiple lots. You were entitled to one home.
And what would that standard be now?
It's the same in code, it's just a different section. So common ownership requires those lots to be aggregated, which is why staff recommended denial.
So it just has to do with that particular side of it.
So the issue for you today is whether or not that aggregation requirement should be upheld.
Okay. You wanted to share something?
I was going to say, I just wanted the representative from Toll Brothers to expand a little bit on, I think, understanding this is a case that we're evaluating on its own, but I think it's dismissing a little bit the activity that Toll Brothers is having in that little corner beyond this lot, just so that.
Sure, I can expand on, so on that particular stretch of Windermere Road, we are currently constructing 4 homes like this on the east side of the road, and we would like to construct an additional 2 homes on the west side of the road. So it's 6 homes on the stretch of this road.
All right, I'm going to go to Commissioner Simrad.
Thank you, Mayor. So District 5 represents almost more than a half a dozen of rural settlements. And when we talk about policy for rural settlements, we constantly see them coming to the podium here, the people's podium, and asking for protection, and they really claw to try to keep the 1 home per 1 acre. And we see it over and over and over and over again. When you purchased both lots, you waived the right to be able to go through with having 2. That was the policy when the letter was written, and it's the policy that exists today. Setting a precedent for, I actually looked at the picture, and it's actually a purposive sample of what you drew when you show the smaller lots, because they're on one side of the road, it's bifurcated by a road. And on the other side of the road, if you look at all the surrounding neighbors, they are actually conforming. So it was a policy then, it's a policy now. It's 1 home per 1 acre, and I think we should uphold our policy. And I think that staff's recommendation was right. Thank you.
Commissioner Scott.
I just had a question to Commissioner Wilson. When you talked about the road and the split between the 4 on one side and the 2 on the other, were there any other concerns, like as far as flooding and things like that in that particular?
Yes.
Okay.
All the above. I want to thank the applicant team for meeting with me and spending some time looking at this, because I don't live far from here, and we do hear from residents about their concerns. Some of those non-conforming smaller lots that were in the applicant's map are in a subdivision that did have a PSP that was required to have some additional things that we're not going to be able to ask in this set of circumstances, like a traffic study or what happens to the overall stormwater when we do this with these 2 lots. So these are substantial, beautiful homes, but I have concerns. It is a dangerous, there's a hairpin turn on Windermere Road when you come around the corner. You know where McKinnon Road is? Yeah. On that road, can't even tell you how much money we've spent trying to keep the speed down. This isn't your fault, this isn't your problem, but it's one of the reasons why when we do have subdivision plans where there are multiple homes being put in as a subdivision, we analyze the impacts on traffic, and we're not getting a chance to do that here because they've purchased these as separate lots. Now, Georgiana explained that with this particular case, and we have another case, so it's like really weird that this is being presented as 2 different cases, because really what it describes is 2 substandard lots that individually, if someone needed to put a dwelling unit on one of those substandard lots, they would go through a variance request, and I think staff would potentially evaluate that differently with the opportunity to aggregate those and still build a home, a single-family home, potentially even with an ADU. There isn't a deprivation of rights. So without a deprivation of rights, really, a variance shouldn't be applied. I mean, if there's something that happens, and I want to back up just a second, because I will say that I pulled this, I think, from the BZA after watching what I found to be a very troubling hearing. The board chair, who is not a District 1 appointee, spoke for me. And he said, well, the District 1 commissioner is concerned about septic. And I don't know why he believed he could assert that, but that was one piece of the troubling dialogue. Just as for you all in the room, if you want to know where I am on things, reach out. My office, we'll meet and talk about it. I think that their role as the Board of Zoning Adjustment is to make sure that we are following our code, and that if there is something that creates a substantial burden to an individual, that there is some discussion about how we can work through that. That is not what happened in this case, and quite frankly, in multiple cases back to back to back. And I'm very concerned with the task at hand for the Board of Zoning Adjustment if they believe they are there. It's not the Board of zoning bypass, right? We got to make sure that our code is still applied. So, I hope that there can be some instructional pieces here on what we look at, the criteria for a variance. And a variance should be applied when the criteria is met, and it isn't met here based on the staff report.
All right.
Well, BZA approved it effectively from what I observed because they believed that there was, I don't know. I can't speak for them any more than I would hope they wouldn't speak for me. But I feel like they did not reference staff's analysis, and staff's analysis lays out the case as it should be, I believe, viewed in our legal obligations that we have as a board.
Essentially, the board discussed pretty heavily the actual vested rights letter and the language in it. I think that they didn't have the opportunity to look at it as, deeply as staff had and, have some of those code sections from 1991, 1992 and look at them in full. The letters, we only have half of the letters. We don't have the questions that were actually asked. We just have the county's responses, and they include partial code quotes, but not the full code, which I think is relevant and important. And so I think the BZA relied heavily on the letters and the vested rights certificate that they were provided rather than looking fully to all of the criteria.
And the record spoke for itself. There was an overwhelming amount of analysis that the staff performed, and I feel like that, I'm not sure if there's an opportunity for that. They're volunteers. I appreciate that they do that work, but it is I believe a disservice to the applicant team, to our staff, and to the time that we spend here if we have to go back and correct potentially what I believe are some mischaracterizations, and there were very much mischaracterizations made that day. So I would make a motion now to support staff's recommendations.
Let me ask a question of staff.
Yeah.
First off. Right now, these two lots are owned by one owner. If the current owner of the two lots decided to sell one of the lots and a new owner came and applied for a variance to build the second home, could that process potentially advance forward?
Mayor, I think where it gets complicated is because they are currently owned by the same party, selling them off. The way that our code reads, from a staff perspective, we effectively consider this one lot today. Even though they're two separate parcels, it's effectively under the zoning code been combined into one lot. So it could be sold off, but would they have lost the rights to develop on that second parcel? That's a question, and we haven't necessarily.
Well, that's what I'm asking.
Yeah.
If it's still land, and let's say this owner decides, look, if I can't build on it, then let me, if it's Toll Brothers or whoever, let me sell the lot.
I don't know, that's not the case in front of us.
Yeah, but I'm asking, theoretically, what happens then?
So theoretically, I support John's position is that the way that we look at it is to preserve the right to build on substandard lots that were owned by different folks. And now we have a scenario where the code would require those to be aggregated together. And so it would depend on the scenario, because the other thing is they're seeking a variance for certain things because of the of what they want to build there, they would need to go back and adjust their plans to build on a lot that's less than 1 acre in a rural settlement. So we would need to evaluate all of those sorts of things too.
Okay, so what I'm going to take away from that is, it's possible that if the lot was sold,
They would have different challenges.
they would have other challenges, but it'd be two separate owners, and there may be some variances associated with this new lot size for either one of them.
Well, then we would also look on the reliance of a new owner. So the case law is pretty specific in creating clear demarcations about when an owner gets to rely on something that a previous owner got to rely on. And so it typically skews that new owners, the more in the future you get, the less you get to rely on the history of what somebody else relied on.
Okay, so in some future board, this board could make some determination. Anyway, I'm just trying to get clarity for everybody involved here about what happens, because it seems that generally what we're saying is just the historical record was done in a way that required the lots to perhaps be aggregated, and that's really what's before us, and that's what staff has recommended denial, the reason why they are recommending that. But if this had come before us where it was two separate owners, it sounds like part of the argument would not be an argument at this point, that if these were two totally unrelated people who somehow ended up with these lots, they might be able to build smaller homes or something, in the rural settlement. I don't know, but it sounds like that's part of what.
I think what they were saying is that it would have needed to have always been separate owners for that to.
The dates matter. The dates matter. So there's
The-
a 57
the dates
date,
matter.
1957 date and a 1991 date that are extremely relevant.
Because they were
Okay.
separate owners.
All right, but, I mean, the board grant variances all the time, but anyway, well, that's not the facts really before us right now, but it seems that the facts that are before us now will indicate that the staff recommendation was an appropriate recommendation based upon the history and then the totality of the circumstances that's before us today. All right, so I'll entertain a motion.
Mayor, can I ask for some clarification? Is it appropriate to ask a clarification question?
I'm going to allow it.
Thank you. So the attorney did mention those two dates, the 1957 date and the 1991 date. So the 1957 date is your zoning code and the 1991 is your comprehensive plan. So the lots were actually created prior to both those dates. And the reason why those letters reflected that it received a vested rights certificate is because it was vested under the comp plan because it was created before the comp plan. And so therefore they said it is a legal lot of record and can be built upon. Because it was in that size, in that configuration before the county ever adopted its zoning code or its comprehensive plan. So, and I think one of the commissioners mentioned that the owner, when they purchased both lots, then they should have known that they would have had to have aggregated. But those letters display that they actually did go through that due process, and they were aware that they could potentially have to aggregate if they owned both parcels, and that's why they went through that exercise and had those letters, and the letters assured them that they would not have to aggregate.
Mayor.
Those are kind of debatable.
I
We'll listen to the county
believe
attorney.
Ms. Hammock is referring to the previous owner. The current owner has owned both lots since 2023, according to the deeds that I've been provided.
Right, but
So the common ownership did not predate 91 nor 1957. It existed in 2023.
So the letter, the April 1st, 1992 letter indicated that because the lot existed in its current configuration as of the comprehensive plan date in 1991, that it would be considered a parcel of record. And the previous owner was in fact the current owner's father.
I disagree.
Yeah, I inherited the lots.
Okay. So, all right, just further complicated it. Anyway, at this point, I'll entertain a motion. All right.
I'm just trying to get clarity. So it wasn't an actual change in ownership. It was just from your father, or?
My father passed away in 2021, and and that's when I inherited the two lots.
You can approach
And
it.
my father, he bought these lots in 1992, I think. And like Mike said, he had hoped that I would build a house next door to him with my husband. And I didn't play the game. I did my own thing. But so he's always had these letters, and he's always told me, like, make sure you keep these letters. This shows that you can build a house next door. Anybody can build on this lot. And so, that's what happened in 2021. He passed away, and I started going through his things and found the letters. I'm like, oh, okay, I need these letters. I, wanted to sell them because, for my retirement and to move on. So that's what I'm trying to do, and I never thought there would be a problem because it looks to be very concrete and it looks, there's the envelope that he kept the letters in, info on the lot to the home saying that I can build a house on it. But anyway, I never dreamed it would be a problem because we had the letters that state that I could, we could build a house on it.
And without getting into you don't have to get into the details. So you got the ownership through a will, through probate, through a trust? How did it?
Trust, yeah.
Through a trust.
Mm-hmm.
Okay, so through a trust, he passed the property to you. Okay,
Correct.
just wanted to understand the time. I was trying to understand the type of transition. I'm good.
Yes, sir.
Georgiana, is a transfer of property like that a new owner?
Well, I think the more relevant question here is there's no debate that the lots are buildable. The question for you is whether or not they need to be aggregated together. And so if you look at the letter, there is a statement that says that the May 21st, 1991 date, that common ownership did not exist at that time. And I believe in their presentation, they showed that the deed where he purchased it was in September 3rd of 1992. So even if you were to stick to the plain language that was in the county's letter on April 1st, there wasn't common ownership at that time.
And if I could just jump in and clarify, there's two different code sections that are relevant here. The code section that is partially quoted up on the screen is from the concurrency vested rights. It's directly from the comprehensive plan. And so that's kind of the planning development section. That's talking about parcels of record for the comprehensive plan, whereas a parcel of record for zoning or a substandard lot of record for zoning is where the aggregation requirement is coming from. So this quote is accurate in saying that for the purposes of vested rights, it's still a lot of record, and it doesn't matter if it's owned contiguously. But for the zoning code, which is separate, it does matter that there was common ownership, and it's that common ownership in 1992 that we're looking at. So even if it were separate owners today, we would still be seeing that it's no longer a substandard lot of record because there was an opportunity to combine them and make a standard lot.
I agree.
Okay. I'll entertain a motion.
I'll make a motion for denial.
Second.
Okay, we have a motion by Commissioner Wilson, second by Commissioner Simrad. All in favor, let it be known by saying aye.
Aye.
Opposed, no. All right, the motion passes, and it is unanimous.
Yes, the second one.
That was D11. We'll go to D12 at this time. We'll open the public hearing on this item, and I'm going to call on Ms. Lakin O'Hara once again to frame this item.
Thank you. The applicant has indicated they would like to just withdraw this application.
Okay. All right. So the applicant is indicating withdrawal.
All right.
So we will not take any action on that today. We'll see if that comes back in some other form. All right. Thank you all for your presence. We're going to move to the next item on our agenda, which is E13. I'll open the public hearing on this item, and Mr. Thal Mueller, our planning administrator, is going to frame this item.
Just one moment, Mayor. Brooke, if you wouldn't mind just clicking for me.
Yeah.
We're missing a piece of equipment over here. Thank you, Mayor. This item is case DRCA 2506143. This is an appeal of a DRC decision, which was in turn, there we go. Sorry, thank you. Determination to uphold the zoning manager's decision regarding the denial of tree removal permit, case TRP 2504068, and notice of violation issued under case FIR 25050295. I will be setting up this presentation, and then I will turn things over to Brooke Tolbert, who's the chief planner over our Arbor section of the zoning division, to go over the specifics of the case, and then we will come back to the overall requested action at the end. So this property is a single-family subdivision, the Keens Point subdivision, approved and constructed around 1997. Roughly 807 acres, 1,000 or so units in the overall subdivision. Property is located in District 1, just off of Winter Garden Vineland Road, along Lake Tibbet-Butler, along the Butler chain. The property is zoned PD, Planned Development District, as the Keens Point PD. And as mentioned, you can see here on the aerial, the property is developed as a single-family subdivision, and specifically a gated single-family subdivision with privately owned and maintained infrastructure. This request was for the removal of roughly 300 trees located along the private rights-of-way along this single-family subdivision. And with that, I will let Brooke present the remainder of the slides.
Thank you. The Keens Point community was first approved in 1997 for 916 residential lots. The PSP included a landscape plan with private streets and street trees on those private streets. On April 18th, 2025, the Keens Point Community Association submitted a tree removal permit requesting removal of 130 trees located in private streets throughout the community. All the trees requested for removal are located on interior roads as identified on the PSP. Per the application, the reason for the removal is road repair and repaving of multiple streets. This map shows an approximate location of the tree removal requests located in the private rights-of-way throughout the community. On April 30th, 2025, zoning staff, including 3 International Society of Arboriculture, or ISA, certified arborists, conducted an inspection of the site. Based on the ISA tree risk assessment qualification, also known as the TRACK program, a level 1 limited visual assessment was performed on each tree requested for removal. During the site visit, it was discovered that 2 live oaks measuring 16 and 17 inches diameter had been removed without a permit. On May 13th, the tree removal permit was denied as it did not meet the criteria for approval for tree removal permits. On May 15th, a notice of violation was issued to the property owner, Keens Point, for removal of the 2 trees without a permit. The violation requires a restoration plan, including mitigation for the trees removed, and the property owner is ultimately responsible for violations that occur on their property. On June 11th, 2025, the applicant appealed both the violation notice and the tree permit denial to the DRC. On July 9th, the appeal was heard at the DRC meeting and no action was taken. The applicant was directed by the DRC to provide additional information regarding the tree removal request, including a utility survey, plans for the proposed road and infrastructure improvements, a more detailed tree risk assessment report for each requested tree, and documentation regarding the health of the 2 trees that were removed in relation to the violation. On August 8th, 2025, the applicant submitted an after-the-fact report from an arborist for one of the trees, tree number 335, the 16-inch live oak. The report references a Florida state statute as justification for removal of the tree. The statute allows for removal of trees on residential or single-family properties. However, this tree was located on a private street, not on a single-family residential lot as required by the statute, and thus should not have been removed without a permit. No reports or documentation were submitted for the other tree removed without a permit, tree number 193, which was the 17-inch live oak. For the tree removal permit request, no additional plans, utility survey, or reports such as a detailed tree risk assessment were provided as requested by the DRC. On December 3rd, the request was heard again at the DRC meeting at the request of the applicant. Having no additional information, the DRC voted to uphold the denial of the tree removal permit and uphold the decision regarding the notice of violation. On January 2nd, 2026, the applicant appealed the DRC's decision to the BCC. Per section 15301, the zoning manager may issue a permit for tree removal as requested if it meets two or more of the following conditions. Criteria number 1 is the tree constitutes an unreasonable impediment to development of a permitted use of the property by virtue of its location in a buildable area where structures or improvements are to be placed and no suitable alternatives exist. These parcels are already developed with a private street network. There are suitable alternatives to complete tree removal that would allow road repair and repaving as originally requested in the applicant's tree removal permit. There's a variety of design and construction strategies that can be employed to preserve the existing trees while accommodating the road repair. Therefore, we found that it did not meet this criteria. Criteria number 2 for developed property, the tree is diseased, injured, in danger of falling, too close to an existing or proposed structure so as to endanger the structure with a high tree risk rating, interferes with utility services, creates unsafe vision clearances, or conflicts with other ordinances or regulations. As noted, the applicant did not provide a tree risk assessment based on the tree risk management methodology. Based on the assessment conducted by the county arborists, none of the trees observed were diseased, injured, or in danger of falling, too close to an existing or proposed structure so as to endanger the structure. In their application, the tree list noted 9 trees where utility underground within root zone, however, did not provide any evidence of the trees interfering with utility services. The applicant did not cite unsafe vision clearances or conflicts with other ordinances in their application. Therefore, it did not meet that criteria as well. Number 3, the tree has been destroyed or has died. As noted, all of the trees were in healthy condition and none were destroyed or died. Condition number 4, the county requires the tree to be removed. The county is not requiring removal of any of these trees. Criteria number 5, the regulated tree proposed to be removed is too close in proximity to another regulated specimen or heritage tree to permit normal growth and development of the affected tree. All of the trees are adequately spaced to permit normal growth and development. Number 6, the tree is not a specimen or heritage tree. According to the tree list submitted by the applicant, there are actually 3 trees that are listed as specimen trees. However, we did spot measurements in the field of some of the trees, and there were inconsistencies between the list that was submitted and the measurement that our arborist took. So, for example, there was one tree listed as a 19-inch oak but was measured as a 24-inch oak in the field, therefore qualifying as a specimen tree, which is subject to additional protection. Number 7, the tree cannot be relocated on or off site, and the applicant hasn't proposed relocation as a part of this. So in their application, the applicant submitted a list containing observations about all of the trees requested for removal. There were no photographs included in the application. All the photographs in this presentation were taken by staff. So here on the left-hand side, you can see they note that this particular tree has damage to the curb, road, sidewalk. As you can see, there's minimal damage or no damage to all of those structures. Regardless, the ordinance doesn't factor into the existing condition of the infrastructure. It's whether there's suitable alternatives. So can that infrastructure be repaired without removing the tree, which again, we believe there are suitable alternatives that exist. Again, they also note issues with the bark, the leaning stem, roots above the soil, and trunk damage. Based on our observation of the trees, it appears to be in good overall health with no visible signs of decline or disease. For this particular tree, don't worry, I'm not going to go through all 130. For this particular tree, they did note curb, road, and sidewalk damage. Again, it's not the existence of the damage itself, it's whether this can be repaired without removal of the tree, which again, there are options. They also note issues with the bark and roots above the soil. Again, we found this tree to be in healthy condition. Here's another where they note damage to the curb, road, sidewalk. Again, no to minimal damage. Also note issues with the tree related to the pruning of the tree, issues with the bark and roots above the soil. Again, there are alternatives to repaving the street that do not require removal of this tree, and the tree is in overall healthy condition. In this particular one, this was one of the trees, one of the 9 trees, as I mentioned, where they did note that there was a utility underground within the root zone. There is no evidence of the tree interfering with the utility that has been provided by the applicant. So again, just the mere presence doesn't meet the criteria of the ordinance. And again, curb, road, sidewalk damage, none to minimal damage, and again, it doesn't necessarily mean that it would be approved for removal, as you can still repair those things without removing a tree, and the tree's in good health. This was one of the trees I referenced earlier. So per the applicant's submittal, it was listed as 19 inches in diameter. When we went out in the field, we measured it as 24 inches, which is considered a specimen tree. They did note damage to the curbs and the road by the tree. Here there's some damage, but again, it can be repaired without removal of this tree. Also, this particular tree backs up to one of their open space tracks, so this is an opportunity where you could potentially move the sidewalk around the tree to give the tree more room to grow and not interfere with the road. And again, the tree is also in good health. So these are just a few photos of all of the trees. Again, I won't go through all 130, but there is a range of trees, but again, all of them appeared in good health. None of them met the criteria of them being diseased or injured. And again, while there are instances of damage to the roads and sidewalks, we believe there are opportunities for repair without complete removal. In relation to the violation per section 15278, it shall be unlawful for any person to remove a tree without first obtaining a tree removal permit or otherwise establish that the regulated tree qualifies for an exemption or exception as provided in the code. Per section 15284, where a violation of this article has occurred, remedial action must be taken to restore the property consistent with a permit for restoration approved by the zoning manager. Per section 15278, the penalty for a violation is $106 per dBH inch if verified on site. Again, 2 trees were removed without approval. Any inches removed must be replaced at a 1-to-1 ratio. So the penalty fine is $1,696 for the 16-inch tree and $1,802 for the 17-inch tree, for a total fine amount of $3,498. The applicant also has the option to replant on site, which would be 33 inches, or they can do a combination of planting and payment to satisfy the violation. This was tree, or the location of tree 193 that was removed without a permit, and tree number 335, which is a 16-inch live oak removed without a permit. In summary, the zoning division denied the tree removal permit for the removal of 130 trees, as it did not meet the criteria for approval. A violation for removal of the 2 trees without a permit was issued. It went to DRC. They requested additional information for the tree removal request. No additional plans, utility surveys, or reports, such as a detailed tree risk assessment, were provided as requested by DRC. Therefore, DRC upheld the zoning manager's decision regarding the notice of violation and the denial of the tree removal permit. So today, the action requested is to make a finding to uphold the DRC's action, to uphold the zoning manager's decision regarding the tree removal permit and the notice of violation issued under FIR 25050295. That was all.
All right, Mr. Thalmuller, anything else for now?
No, that is the accurate DRC motion and the action requested.
Okay, then I'm going to go to the applicant or his representative for any comments at this time.
Good afternoon, Mayor, Commissioners. Dan O'Keefe with Schutz & Bowen, 300 South Orange Avenue, Suite 1600. I am here on behalf of the Keens Point Homeowners Association. Mike Stewart is the president of the Keens Point Homeowners Association. And first off, we had the opportunity to meet with the majority of the county commissioners and go through briefings yesterday and on Friday. I think it was Friday. And based upon the feedback that we got, we thought that there might be an opportunity to provide some additional information or come up with a different course of action if we had a continuance of this item. So first, we would like to request a continuance of this item to either a date certain or 2 weeks or 4 weeks from now in an effort to find a suitable resolution.
If, John, if we continue today, when's perhaps the first available time?
Mayor, the afternoon of March 24th, we have a full agenda in terms of public hearings, so either April 7th or 21st.
Okay, so those will be the potential options, April 7th or the 21st is what I'm hearing. And if there's not objection from the district commissioner, if you want to continue it to give them further time to have conversation.
Mayor, just for clarity, we would need to open it up for public comment,
Okay.
even if the board chooses to continue it today.
All right. Do we, if you'll stand by for a moment, I'm going to open it up for
Thank you,
public
Mr. Mayor.
comment.
Thank you,
Okay.
Commissioner.
All right. Do we have members of the public present who wish to be heard on this item?
We do, Mayor. We have 4 speakers for this item.
Okay. So we'll call them perhaps in the order in which you received them.
All right, folks, I'm going to call your names in order. Please line up along the back wall in the order called. When you approach the podium, please begin with your name and address for the record. Our first speaker is going to be Gabrielle Milch, followed by Deborah Green, Val Mobley, and Julie Harris. And Julie, you're going to have 1 extra minute.
Good afternoon. My name is Gabrielle Milch, and I'm here today to speak about the tree ordinance and request that you give them the continuance, but I have some concerns about removal of this many trees in a mature subdivision. I understand some of the aesthetic component parts of it is hard. I have worked as the Riverkeeper, St. John's Riverkeeper Middle Basin. I've worked as an extension agent at the University of Florida. I was a licensed arborist, and a lot of times people remove trees simply because they're in the wrong place, and as they mature, they're not as pretty. So I did get an opportunity to do some research on this situation and found the reports from the Homeowners Association, their Infrastructure and Waterways Board, and they've been toying with this idea of fixing the roads for quite a bit of time. And so this application and all has not had sufficient information. So I would like to suggest that you all keep on with the denial of the removal of these trees. And I am also in a homeowners association, and we're going through a similar situation. My subdivision is is 50 years old. It's in Orange and in Seminole County. And we're doing a tree canopy study where we're looking at walkable situations because our kids ride their bikes and walk to school. And so it's very important to have shade. Last year, we had over 100 days of over 106-degree temperatures in Central Florida. So it's getting really hot out there. So trees are a really important thing, and I could tell you the list of important things why trees are important. So I just, this is a very large subdivision, and they have removed other trees besides those I found in that report. So thank you.
Mayor, can we ask a
All right,
question?
thank you, Ms. Milch.
Does she live in that neighborhood?
It sounds like a different neighborhood, but you live in Kings Point, ma'am?
No, I live in Wakaiva Hunt Club subdivision.
So that's totally different. Okay.
Christine
All right,
Morris.
but she's a tree advocate. Okay, thanks. So we'll move to the next speaker.
Good afternoon, Mayor and Commissioners. I'm Deborah Green from representing Orange Audubon, P.O. Box 274, Apopka. And I also am urging the Board of County Commissioners to deny this application. Continuance is fine. More information, more alternatives would be great. But we had an opportunity to provide stakeholder input on the tree ordinance, and we were very proud of the product that came out to protect the tree canopy of the county. And for the reasons of ecosystem services, shade, for cooling, carbon sequestration, and for birds, which is Orange Audubon's particular concern, the caterpillars for the birds live on the trees, and that's to remove them, you're increasing the decline of the birds. So I just recommend following staff's recommendation to deny this.
All right, thank you, Ms. Green. We'll move to the next speaker.
Hello.
Hello.
Good afternoon, Mayor and Commissioners. My name is Julie Harris, and I am a 22-year resident of Kings Point. I am asking you to please deny the HOA's appeal to remove approximately 130 trees from our community. The DRC has already reviewed this request multiple times and denied the permit. I ask that you please uphold these decisions and the county's tree ordinances that were specifically created to prevent this type of large-scale removal of healthy trees. Roads and sidewalks naturally deteriorate over time. The roads in Kings Point are overdue for repair, and the damage we are seeing today is the result of delayed maintenance as much as the tree roots. Trees should not be blamed as the sole cause when infrastructure aging and postponed repairs play a significant role. The HOA claims the roads cannot be repaired without removing the trees. However, I have a written report from well-known Orange County consulting arborist Mary Edwards stating that the trees on my property are healthy and that mitigation options exist to repair the roads while preserving the trees. She does not recommend removing them. Orange County itself maintains roads throughout the county in areas with mature trees, proving that mitigation strategies can work. I have a copy of her report if you would like one. The HOA has also claimed that the trees in Kings Point were overplanted when the community was first developed and has used this as additional justification for removing them. However, consulting arborist Mary Edwards specifically noted that the street trees were not overplanted. My understanding is that these trees were planted in accordance with Orange County's canopy tree spacing requirements. The debate over overplanting has no bearing on the proposal before you today to remove these trees. These 130 trees are also just the beginning. They represent only a small portion of the streets in our neighborhood. Once these trees are removed, the same reasoning can be applied to other streets, eventually impacting the entire community. On my street, Stone Mason Court, the HOA is proposing to remove 9 trees, 40% of the street's trees, with 90% located on one side of the road. Yet we are told this will not impact the neighborhood's canopy. Removing nearly half the trees from a street clearly does have a real impact. One example the HOA frequently points to is tree number 84. It was up there a few moments ago and it's on my property. While there had been some gradual road damage over time, the major damage occurred in March of 2025 when an Orange County garbage truck drove over the curb, causing it to essentially explode. The HOA has allowed that road to remain unrepaired for a full year while simultaneously arguing that it is a danger and liability. I do have a video of the garbage truck if you would like to see it. If the standard becomes removing every tree that contributes to road or sidewalk damage, eventually most, if not all, of the street trees will be removed. Trees naturally interact with infrastructure as they mature, but the benefits of these mature trees, shade, stormwater management, cooling our neighborhoods, and preserving property far outweigh the challenges. Your tree
Thank
ordinance.
you, Ms. Harris.
Oh, I can't finish?
No, that means you just ran out of
Oh.
time.
Oh, okay.
Thank you.
Even my husband's minute?
He
gave me his
he's
minute.
here. Did-
Yes, that was the extra minute.
That was, you
Oh.
had the extra
Okay.
minute.
Oh, I just had my summary. No.
Okay.
No, okay.
I think we got what you were saying. Thank you. All right.
Val Mobley, 226 West King Street, 32804. I live in College Park, not in Kings Point or in Windermere, but I am the Lorax right now. I speak for the trees. Overplanting? How could you possibly overplant trees? They're going to breathe for us and give us oxygen. Y'all all know this, so that's not the point. The point is the town of Windermere is known for its tree canopy. People go there, tourists go there to see this quaint community and the beauty of it because of the trees. Now, maybe they're not going to Kings Point because it's a gated community, but you're part of this bigger community called Windermere. It's quaint, it's beautiful.
Be accomplished with a continuance, maybe compromise on the number of trees. I just don't know what could be accomplished, and I doubt if there's anything there. So the importance, there's, well, many important aspects of these large specimen trees and the CO2 that's sequestered. Removing these large live oaks actually creates more of a heat island effect. And we know here in Central Florida, we're dealing with very high temperatures. So just keep it short and ask for denial. Thank you.
All right, thank you, Ms. Holt. Do we have any other speakers?
I believe that is our last speaker for this item, Mayor.
All right, so we're going to close the public comment period of time, and are you all still desirous of a continuation?
Yes, sir, Mr. Mayor.
All right, so Commissioner Wilson, I'm going to go to the district commissioner if she will entertain the continuation.
Well, I was going to say, and there may be other questions from our board that if it's helpful, I mean, are we allowed to go through that process, or do you want to hold off until, because I do think there's, okay, I'm hearing.
Just so you know, Commissioner Wilson, there's nothing here that I'm willing to compromise on. My vote today will be the same as my vote will be later.
And
we have a code. You know, the trees don't seem to be impacting any visual aesthetic. The primary purpose of an HOA is to protect property values. Mature trees enhance property values by 7 to 10%. The purposes align. We have a strict tree ordinance. There's nothing that I will
listen,
hear.
you know, I don't disagree with you, but I do want to make sure there's due process rights, and we want to make sure that they have their opportunity to respond. I think hearing from staff, they've been seeking information all along that was potentially an oversight by the applicant team. And if they have additional information between now and the rescheduled date, I think this would be a good time for that information to come forward. Would there be a date possible for?
Again, the two dates that we would look at in April would be either April 7th, or ideally and preferably April 21st, just given the context of the hearings that we already have scheduled for April 7th. So April 21st at 2 p.m.
Okay.
We're agreeable.
All right, I know staff has given us an extraordinary amount of time also, so I'm.
Probably April 7th would be better, but we're agreeable to either one that the board would consider.
Preference of the board?
I hear, what's your preference, Commissioner?
I've been studying this for a very long time, so I would also be ready today, but like I said, I do not want to deprive them the right to be able to present what they feel like they need to present. And so we can go ahead and reschedule it for April 21st at 2 p.m. I'll make a motion for a continuation.
All right, we have a motion to continue to the afternoon of April 21st. There's a second by Commissioner Scott. All in favor, let it be known by saying aye.
Aye.
Opposed, no.
No.
All right, motion passes 5-1.
Thank you, Mayor. Thank you, Commissioners.
All right. All right, we'll move to the next item. This is item F14. We'll open the public hearing on this item. Mr. Thalmuller, we'll look to you to frame this item.
Thank you, Mayor. This item is case number PSP 2503071. This is the Silverleaf Plan Development Regulating Plan Phase 4 Preliminary Subdivision Plan. This is a request to subdivide roughly 20.36 gross acres, generally located west of Porter Road, south of McKinney, north of Schofield, just east of the Orange County, Lake County line, within Horizon West Town Center Village for 50 single-family residential lots and associated tracts and infrastructure. Subject property is located in District 1, as previously mentioned, very off to the western edge of the county there. Here we have the Horizon West Special Planning Area land use map. Property is designated corporate campus mixed use on there, specifically for the Silverleaf PD. And as mentioned, the property is zoned PD. Again, Silverleaf PD regulating plan. Here we have an aerial of the property. You'll notice it is currently undeveloped. Surrounding area also within that Silverleaf regulating plan is in the entitled and in the process of development with a variety of single-family, multifamily, and commercial and other non-residential uses as master planned within that regulating plan. Here we have the layout of that subdivision plan. You can see here the individual single-family lots and tracts, infrastructure, and connections to existing roadways and facilities within the area. And with that, the recommendation is to make a finding of consistency with the comprehensive plan and approve the Silverleaf Phase 4 preliminary subdivision plan, subject to the conditions listed under the DRC recommendation in the staff report. And with that, staff and the applicant are available for questions.
All right, is the applicant on this item present? If so, you can come forward and offer any comments or questions or representative.
Good afternoon, Mayor, Commissioners. Mark Stelly, Civil Engineer, Pape Dawson, 2602 East Livingston Street. We're in agreement with staff's recommendations and available to answer any questions if you have any.
All right, so does Polis and Bennett have a new name? Is that what I heard?
We do.
Okay,
Pape Dawson is the name.
What is it?
Pape Dawson.
Pape Dawson.
P-A-P-E, Dawson.
Okay.
So
you said Polis and Bennett, and I heard somebody say earlier a different name. Okay, so you're in that process of changing.
No, we changed. It's just, you fall back into.
You said it a lot longer than
You got to do what Prince did and be formally known as.
I may work on that.
Okay, all right, I got you. All right, stand by for a moment. Do we have members of the public present who wish to be heard on this item?
We have no speakers for this item, Mayor.
All right, then we'll close the public hearing portion. We'll go to the District Commissioner, Commissioner Wilson.
I'll move the recommended action.
Second, Gomez.
Second by Commissioner Gomez. All in favor, let it be known by saying aye. Opposed, no. Motion passes, and it is unanimous. All right, thank you all for your presence. The next item is item F15, and it is my understanding this item is been requested to be continued.
Yes, Mayor, we are requesting a continuance till April 7th for this item.
April 7th? All right, so with that, we'll open it up.
And we have no speakers for this item.
No speakers, the applicant, I don't see the applicant. Okay, would you like to speak? No, okay, the applicant is waving no. So we'll close the public hearing portion. Commissioner Gomez-Cordero, would you like to offer a motion?
Yes, motion for approval. Motion to continue for April.
Second.
April 7 at 2 p.m.
Second, Uribe.
Second by Commissioner Uribe. All in favor, let it be known by saying aye.
Aye.
Opposed, no. Motion passes, and it is unanimous. And now we'll go to the next item on our agenda, item G16. We'll open up this item for public hearing, and Mr. Jason Sorensen, our chief planner, is going to come forward and frame this item.
All right, thank you.
Can I bring a comment up? May I bring a comment up?
On this?
Yeah, no, this is my case, I'm sorry. This is the one that Jason's getting ready to.
Oh, okay, let's go ahead.
I didn't want, for the sake of time for all of you guys, we went through this last night and I've already talked to the applicant. This was just a small issue, that was why it was pulled. So unless you guys want to hear all about a duplex, I'm good with allowing this to move forward unless you guys are, all vested in learning about a duplex on the side of a house. Okay, you get where I'm going? This, I even think the comments that are here for it, we had a little issue, I pulled it, we had a community meeting last night, we're really settled, but if you want to make staff and the applicant go through it extensively, it's just a.
I'm supportive, I just want to make sure we've got all, once again, due process right.
Yeah, I'm just trying to save you guys an extra 30 minutes. Okay. So that's basically it. I just, this is unusual, so I'm just trying to save Jason from having to go through this and the applicant. So it was a technical thing.
Are you saying it was on consent, you pulled it, but you had a community meeting and
we're satisfied.
Residents are,
Okay, so
everything is good?
So
you would have.
So unless there's a public comment that needs to be said, I don't know you.
We still have to open it up, right? We got to open it up. It's advertised, so Mr. Sorensen is going to have to frame the item, and then if the applicant wants to make any comments, they can, and then if there are anybody here who wants to make any public comments, they can, but you heard the kind of commentary, at least at this point. Okay. All right, Jason.
All right, thank you, Mayor. I'll just go quickly through this then. The request is to go from R1A to R2. The request is for a duplex, and this is located in District 3. Currently, the future land use is low-medium density residential that allows up to 10 units per acre. Currently, R1A request is R2. There are other duplexes, a couple other in the area, and this is an aerial of the subject property. We are south of Michigan, east of I-4. We did have a community meeting. There were 2 community meetings, 5 residents at each. Generally supportive of the request. There was one exception at last night's meeting. They just thought that the property should remain single-family. So the requested action is to approve the R2 request.
All right. Does the applicant or representative want to make any statements?
Hello.
Hello.
Thank you for having me. My name is Angelina, and I am the current owner of property located on 750 28th Street in Orlando, Florida. I have owned this house for about 14 years, and I lived previously in this house for about 2 as a renter. So when I purchased the house, it was exactly the same configuration as it is now. I haven't changed anything whatsoever. So when gentlemen built this house, I know the family that built this house previously. So they built the house with an intent to have an addition built onto it, so they can use it as a multi-family home, like multi-generational. So the son and his daughter was supposed to be moving to the second side of the house. So, and now I just wanted to make sure that it's all legal and it stands in the ground. So like I can use it as a duplex basically, so it's 2 entrances to the house. And that's all I'm asking. I'm not changing anything, I'm not building anything, and it's just that's all.
Okay, stand by then. You can have a seat if you like.
Okay, thank you.
All right. Do we have members of the public present who wish to be heard on this item?
We do, Mayor. We have 2 speakers for this item.
Okay. Okay,
no
did I hear you
speakers
say
for this item.
you're withdrawing from wanting to speak? Okay. Do we have any other speakers? Okay. If not, then we'll close the public hearing portion at this time, and I'll go to Commissioner.
Motion for approval.
Second, Wilson.
All right. We have a motion and a second. All in favor, let it be known by saying aye.
Aye.
Opposed, no. Motion passes, and it is unanimous. Thank you for your presence. Okay. And we'll move to the next item on the agenda, which is item H17. We'll open the public hearing on this item, and Mr. Sorensen, you're recognized.
All right, thank you, Mayor. This next item is a regular cycle amendment, a transmittal hearing. The case number is 2026-1A41. The request is to change the future land use map designation from commercial and low-medium density residential to medium-high density residential, which allows consideration up to 35 units per acre. The subject property has 14.06 gross acres, 12.59 net acres, and the request is for 322 multifamily dwelling units. The subject property is located in District 4. Again, the future land use existing is commercial and low-medium density residential. Proposed is medium-high density residential. And this is the current zoning of C2 and R2. There is a land use plan that is in process. So the proposed zoning that would come later, if this is transmitted to the adoption hearings, would be rezoning request for PD. This is the aerial of the subject property showing it south of East Colonial and generally west of Rouse Road. 667 public hearing notices were sent to an area extending beyond 700 feet from the subject parcel. To date, we have received 5 responses in opposition, stating concerns for flooding, opposition to multifamily development at this location, increase in crime, traffic, and noise, overdevelopment of the area, and wildlife concerns. A community meeting was held on January 14th with 19 residents in attendance with concerns for traffic, stormwater, impacts to wildlife and wetlands, and access management. So right now we are at the board hearing for the transmittal portion of this process. If this is transmitted, it would be sent to the state for their review, and it would come back for adoption hearings, again, also at that time with the land use plan PD rezoning request. Staff is recommending, staff as well as the local planning agency is recommending approval or to transmit the request. At the local planning agency hearing, there was 1 speaker present to speak on the request with concern for access management and traffic safety. Staff is available for any questions.
All right, thank you. Is the applicant on this item present?
Good afternoon again, Rebecca Hammock, Pape Dawson, formerly Polis and Bennett. I'm one of those. So I'm here today with the developer, who is Eastwind, as well as our development team. But before I get started, my business address is 2602 East Livingston Street, Orlando, Florida, 32803. So again, the developer for this case is Eastwind Development. They do have over 20 years of experience developing apartment communities in Florida, including 10 projects in the Orlando MSA. I'm from Pape Dawson, but I'm here with Biotech Consulting, Kemley Horn for the traffic analysis, and Ackerman. So if there's any specific questions, I will refer to the rest of the development team. So as Jason mentioned, the request before you today is for transmittal of a requested future land use map amendment. We are requesting a concurrent rezoning to plan development, which is in process with the Development Review Committee. So that is still under review. We are requesting the future land use map amendment and the rezoning in order to develop a 316-unit multifamily apartment complex. So the subject property is located on the south side of East Colonial between Dean and Rouse Road. It is an infill lot in an existing mixed-use area. There's retail commercial in the area as well as single-family residential. There is a fancy fruit retail store adjacent and a bowling alley across the street. So the current future land use designation of the property is split. It currently has a low, medium density residential as well as commercial. The majority of the property does have a commercial future land use, and we are requesting a change to medium, high density residential, which permits a max dwelling unit of 35. The current zoning on the property is C2 and R2, and we are requesting a planned development zoning. Under the current future land use designation, approximately over 700,000 square feet of retail commercial could be built on the site. So we are proposing to amend it to residential with a max density of 22.7 dwelling units per acre. So although the future land use category would allow 35 dwelling units per acre, we are going to limit the density through the planned development zoning. So here is a conceptual development plan, and this is the plan that is being processed through DRC currently. We are proposing 316 dwelling units, and we believe that multifamily in this location will increase supply. We're proposing four-story buildings, a clubhouse, a swimming pool, passive recreation and open space areas, a pond overlook, and dog walk area, and dog waste stations. Here is a rendering of the proposed apartment complex. So currently, we did have our community meeting on January 14th. Following that, we had our LPA meeting before the Orange County Local Planning Agency on January 15th. The LPA did recommend transmittal of the requested future land use map amendment. So at the community meeting, a few of the items that were discussed and brought up as concerns from the neighboring property owners was stormwater management, traffic and site access, and residential compatibility. So currently we do have the St. Johns River Water Management District permit that already has been obtained. And the post-development discharge is less than or equal to pre-development by code requirements. And all drainage discharges will be to Park Manor Canal and not towards any residential properties. With regard to traffic and site access, there will be no changes to the current access location. It will stay in the location that exists and is approved by DOT. And in terms of residential compatibility, we do believe the change in future land use to residential will actually create a transition between the commercial uses along 50 to the single-family residential to the south. We believe the project will have benefits to the community. We believe it advances many of Orange County's planning objectives. We believe it supports nearby employment centers by providing housing opportunities near major employers. And we believe it is has quality community amenities that enhance livability and neighborhood character. We also have included strong vehicular and pedestrian connectivity. And in fact, there is an existing Lynx bus stop at Park Manor Drive just east of the site. And we also did hear from the business owner of the bowling alley that is across the street, supporting the request, and was excited that there may be additional rooftops in the area to support his business. So a transportation impact analysis was performed for the future land use map amendment, and the TIA was reviewed by the county, and all the comments have been addressed. The conclusion of the impact analysis is that the proposed FLU amendment results in a decrease in max trip generation potential, and that's because of the change from commercial to residential. So the TIA conclusions found that there are no roadways deficiencies identified, no new intersection deficiencies were identified, and no turn lane improvements were recommended at the project driveway. And of course, access will also require DOT approval. And with that, that concludes my presentation, and I would be grateful for a motion and a vote of transmittal of the future land use map amendment, and we're happy to answer any questions that you might have.
All right, thank you. Stand by for a moment. You can have a seat while we're doing this. Do we have members of the public present who wish to be heard on this item?
We do, Mayor. We have 5 speakers for this item.
Okay.
Hi, folks. Going to call your names. When I do, please line up along the back wall in order. Please approach the podium in that order. Begin with your name and address for the record. First speaker is going to be Dylan Jensen. And Dylan, you're going to have 1 extra minute, 15. There we go. After Dylan, we will have Ray Lord, Sally Gann, Patricia Beal, and Charlene Waters.
Good afternoon, everyone.
Afternoon.
My name is Dylan Jensen. I reside at 8102 Stonebrook Drive, Sanford, Florida. Just let me know when I can begin.
You can begin.
Okay. So I'm speaking today with Mr. Rubin. Him and I are business colleagues. I've done some draft work as an administrator. I've worked with Mr. Rubin heavily in his business. What he does is he does property maintenance and management services. He'll do like a property manager for over 1,500 properties, and making sure their safety, they remain in value, things of that nature. So we are in support of the development project. Almost essentially what you say in the presentation, we believe. The only thing that I would ask in consideration is do remember the traffic corridor. The latest numbers we were able to pull is that there's 45,000 cars that go through that stretch right there in front of the development site per day. And there's 2 U-turns in front of that site, which I believe is horrific for a development community, that they would consider putting a traffic light in front of Grayson. Not only that, I believe that having this attention to the area, this section of East Colonial is largely underdeveloped. I would implore anybody to just go walk it. Mr. Rubin's been doing 311 requests. He's been asking for sidewalks to be repaired. There's been trash all over the properties. There's been some homeless on some of the properties around the developing site, maybe to relocate them, things of that nature. And I think overall developing this right here would enhance the community. It would bring Orange County FDOT together to fix some issues. And instead of it kind of being an eyesore liability to the community, that we can turn this into an asset. Because remember, developing the site as well brings jobs. It's tax revenue, things of that nature. Overall, it's just a win-win for everybody. And I really would like it to remain that way. Thank you.
All right, thank you. If you want to stand by just for a moment.
Good afternoon. Ray Lord, 10651 Nadia. So the concerns of me and my wife have about this zoning increase include the additional demands on our first responders, fire, police, and ambulance. Also traffic and flooding. This property has A&E flood zone and wetlands on both sides. The wetlands mentioned on the east side during the community meeting, but it wasn't mentioned about the ones on the west side, which are substantial, I think, class 3 wet zones. It'd be nice if it had a buffer. Also, the beautiful heritage trees, we'd hate to see them taken down for a parking space. My wife and I and our young grandkids bike and walk across Grayson multiple times daily. And Grayson has sidewalks on both sides. Grayson is the street west of this property. It has a 25-mile speed limit, which hardly anybody observes. They mostly do 40 and plus. Approving more density does not appear to add to the quality of our older neighborhood. Hopefully, when this property is developed, it could include some homeowners. And of course, we're interested in what our commissioners have thoughts on this. Thank you.
All right, thank you. Next speaker.
Good afternoon, Mr. Mayor and Commissioners. My name is Sally Gann. I live at 927 Park Manor Drive. I'm a 53-year resident of Park Manor. I've seen all the changes in East Colonial, not all of them good. This one is not going to be good for those of us that live in Park Manor. They talked about traffic and the U-turns. When the state 4-laned, or actually 6-laned Highway 50 they put a U-turn in for us to get to our homes. The entrance to this development would be opposite that U-turn. And right now, between 5 and 6 p.m., you cannot make a U-turn there. It is impossible because nobody's going to let you through. You go up to Grayson, nobody's going to let you go across Grayson. Means you have to go up to Murdoch where there is a traffic light, make a left turn, and then go through other developments in order to get to our homes. This is not going to be an asset to East Orange County. There are apartment complexes all up and down Rouse Road. There are college developments going in on East Colonial Drive. This is not going to be an asset. You're going to destroy live oaks. You're going to destroy old growth oaks and destroy wetlands and also wildlife habitat. I urge you, please do not approve this. Thank you.
All right, thank you for your comments. Okay.
Hi, I'm Patricia Beal. I live on the Grayson side of this project also, over in Park Manor. And the developments seem exceedingly high number of apartments for a small area which already encompasses a large number of businesses, hotels within 2 blocks, and apartment buildings surrounding like the 4-block area on Rouse and East Colonial. The traffic already takes 8 to 10, 15 minutes to take a right turn onto Colonial a lot of the time. There's a lot of traffic in and out of the small businesses in the Rouse area on Subway, Tuffy, CVS. There's also quite a bit of difficulty in trying to do U-turns already. And I just want to reiterate that I do have a question. If they left the low density to moderate, how many apartments or houses could they build in that area? That's the proposal, correct? From going to a low commercial?
This is the time for you to make any statements, but as we move forward, the applicant may respond to that question, or we may have staff, but this is your time right now. We're not going to go back and forward right now. Okay.
Well, I'm just reiterating what everyone else is saying as far as the traffic is a huge concern, the congestion in that area already, and that would be an extremely large amount of population in a very small area.
Okay.
Thank you.
All right, thank you. The next speaker, please. Hi.
I'm nervous. Okay, so.
Just pull that mic down closer.
Oh, I'm sorry.
See that mic? Just pull it closer. There you go.
Okay.
All right.
Charlene Waters, 10814 Exuma Street, 32825. Okay. The complex, they want it to be 4-story. They're going to build 4 stories. Can you imagine looking out your house window and seeing 4 single-family homes, 1 story, and they want to build 4 stories? What is that going to do to what we see when we look out our window? And what is it going to do when the apartment, the 4th story, looks out their window or their balcony and they're looking down at all our houses? The traffic is, like everyone else said, horrendous, so I'm not even going to go there. We maybe want a continuance. This is our first time doing any of this, any of us, and all of them people sitting there for the most part are here for this. So we've been trying to get together, and we want to stop this. We understand that it's going to go to Tallahassee next, but if Tallahassee stamps it, and it comes back here, we're not going to be able to stop it. So if we could get some kind of continuance on this, the roads, so you are aware, Grayson and Park Manor Drive, they already flood. We have pictures of after the storms, and we have some of after a hurricane where the subway that they were talking about and other businesses, it was flooded. But we didn't know we could do that. Then the last thing is we just need a little bit more time if we could get some kind of continuance so we can get our stuff together. And they did have a meeting, and we met with our commissioner, and the meeting here was the next day. Without any notice, most of us work. I took the day off for work today. So we just need time to stop this. Thank you.
All right, Ms. Waters. Thank
Have a good
you.
day.
Next speaker.
Hello, I am Sabrina Klein. I'm sorry, I'm very nervous. I've never done this before. I am also with this community of people that would like to stop the 322
Just
units.
give us your name.
Sabrina Klein, C-L-I-N-E. I'm here to oppose the development of the 322 unit that they're trying to put in on 50 right now. I live right across the street from there on Rouse, and I'm with these people on everything that they're saying. That neighborhood did not flood until recently, and that was due to the things that they built behind all of those communities. They did the same thing they're trying to do here. They knocked down a bunch of trees, they filled in an area that was, essentially flooded for swamp water, and then they built a bunch of houses up on it, and then all of the neighboring houses around that neighborhood began to flood because of that. There's significant traffic, like you guys have already heard of. Getting into those units alone is going to be a nightmare. We have one grocery store, one Walmart, and then your next grocery store is miles down the road. So all of those people, you have to think, so 322 units, you're going to have at least probably 2 people per unit, at least 1 to 2 cars per unit. So then you're thinking, hey, now we have 2 cars per house. So that's 644 vehicles now coming out of there, 644 people plus kids plus everything else that are all now crammed into that tiny little neighborhood. And I don't know if anybody knows, if you're looking at it from above, we don't have much green space left over there. I've been fighting developers about the swampland behind our houses for the last year now because they keep trying to fill in swampland and build an apartment complex. Unfortunately, if you go down in there, which I have, I will get my hands dirty, and once you get down in there, that's 2 feet down in there, and it's filled with water. And even during our drought right now, it still has water. That is where all of that water trickles down to. And if we allow something like this to get built and crammed into that tiny little area that we have, we're screwing all of the residents in that area. Thank you for your time.
All right, thank you, Ms. Klein. Okay. We normally don't allow clapping and the making of any kind of noise, but y'all seem like you're just good people. I'm giving you a lot of deference this afternoon, but hold it down. All right. All right, so I think that's the last speaker, if I'm not mistaken. Okay, so with that, I'm going to ask the applicant, you can come up for any rebuttal comments. You heard at least one question that was asked. I don't know if you can answer that question or not. It may have to be a staff response, but go ahead.
Sure. Again, for the record, Rebecca Hammock, Pape Dawson. So the current future land use on the property, the majority of it is the commercial future land use. Only a small portion of the property has an existing residential future land use. So I don't know what that would calculate out in terms of number of units. But with the intensity of what could be built there currently is more intense than what we're proposing with the multifamily dwelling units. With the current FAR of commercial, we estimate based on the max floor area ratio that you could build over 700,000 square feet of commercial. With the change in future land use, that would lower the intensity of the use in terms of traffic generation. And I'll let James from Kimley Horn answer some specific questions related to transportation. We did hear the concern about the U-turns. That is an existing condition. And regardless of whether the site was developed with commercial uses or residential uses, that condition would be there.
For the record, James Taylor, Kimley Horn, professional engineer, 6876 Marwick Lane in Orlando, Florida. So hopefully Ms. Rebecca answered your question regarding the future land use intensity. This is what we would consider a down zone where the trip generation potential today will be a lot less in the future with this proposed amendment being approved. This application will need to go to DOT for access. The existing U-turns out there today have been quantified as the delay has as well, both today and in the future with the traffic. The existing turn lane out there today can accommodate the future build out. We had a pre-application meeting with DOT in March of 2025, and there was no discussions of closing this meeting open. It's here to access this property as well as serve those existing U-turns. And all of this is covered in the traffic study in your packet. Let me know if you have any more questions.
All right, stand by. All right. Anything else you want to add?
Yes, please. There was a question regarding wetlands, and there are some existing wetlands on site, approximately 1.47 acres. It's an isolated wetland, class 3, so it's not a quality wetland. We are proposing to impact that wetland. There are some surface water areas that are off-site. We are not proposing to, and there's some on-site on the west, but we are not proposing to impact those and are providing a 50-foot buffer.
Okay, thank you. We're going to go ahead and close the public hearing portion then at this time. And I'll open it up for any questions by members of the board before we go to the district commissioner for a potential motion. Commissioner Wilson?
Yeah, I had a question. If someone from EPD is still here or somewhere, I see Tim Hall, you're in my target site here. They said class 3 wetland and they offered some kind of a buffer, but why wouldn't this be classified under the new wetland code with the automatic required upland buffer?
So the reason class 3 is still referenced in this case is because it's in the econ protection area. And we didn't revise that code. And in that code, the econ code still utilizes class 1, 2s, and 3s for the purposes of buffer sizes required.
Okay, so for those of you that are listening in and don't understand what all that like very coded language is, what that means is the science has shown us that what used to be considered low-grade wetlands are actually pretty valuable wetlands. So class 3 wetlands are still valuable, they're just cut off from other wetlands. But as it turns out, as you eat up more wetland, everything becomes a cut-off wetland. So it was not a sustainable way for us to identify wetlands in development, but the upland buffer is the most protective piece. If this was outside of that econ, what would the upland buffer be required to be?
It'd be 100 feet.
And can I ask the applicant team if they'd be willing to honor that, understanding there was a lot of science that went into the update that code now requires for the upland buffer?
John Miklos, Biotech Consulting, 3025 East South Street, Orlando, Florida, 32803. Commissioner Wilson, I believe you're talking about the surface water in the northeast corner.
It's identified. There's in the report. There's an identified class 3 wetland, and
that
Rebecca
wetland,
just mentioned the 50-foot buffer.
We have an application in for removal of that wetland.
Okay, so
she's referring to the
I thought we were referring to the surface.
She's referring to the surface water.
Right.
This 50-foot buffer, and then this one's impact.
So the wetland and the surface water connection in the northeast corner is connected through and connects down through the econ chain. Meeting code, because the county neglected to update the econ or Wekiva code as it relates to buffers. We're meeting the code in that criteria.
No, I understand that. That wasn't my question.
The site plan as it lays out, I won't speak directly for the applicant, but the site plan is very tight as it sits. I don't know that there's room for it. Additionally, there's no buffer there to speak of. I know there's concern about this wetland and the wetlands on site, but this site was all but devastated about a decade ago when DOT was working on using the property as a laydown yard and for the improvements on Highway 50. And also when they constructed the pond behind this site, they cut a road through the wetland that's left and isolated on the property. They removed most of the native vegetation
Now, listen,
across
you
6
are
acres of
absolutely
it.
confirming my fear, which is that probably those impacts are what you're now hearing the residents suffering with. So making a bad situation worse is what my question was directed towards.
Understood, but a buffer on a ditch that has already, on an area of the site that's already been filled isn't going to alleviate that issue.
So you're asserting that that Class 3 wetland that's identified in the application is a ditch that doesn't necessitate a buffer?
I think when you're talking about the Class 3, I think you're talking about the wetland in the southwest portion of the property.
I'm describing what was
that
in-
wetland, we have an application in for removal. And it's a staff-issued permit application.
Okay.
run
Let me
this?
just check. Commissioner Wilson, will you finish right there?
I mean, it was an answer, so yeah, I mean, I know where I am on this.
Okay. Then Commissioner Simrad.
Thank you, Mayor. So I have several issues. One is that there's no way that 4 stories is compatible with the surrounding neighborhood. There's no way. That's the first thing. So I don't know how this passes the compatibility test. And I don't really want to refer to what Vision 2050 has it zoned for, because our Florida state has failed to pass a glitch bill. So Vision 2050 is a pie in the sky right now. So right now it's not compatible. I also, in today's market where families are incurring property insurance, chronic rate hikes, every single wetland is important and valuable. I don't care if it's a 1, 2, or 3. Every single one is valuable right now when people are paying rate hikes year over year over year. And it's no mystery why we're having to pay it. It's because we're filling in wetlands that Mother Nature needs to properly drain during storms. So I don't support any form of development that fills in any type of wetland. And it's frustrating to hear developers describe a wetland as not valuable when we see so many people struggling to pay property insurance increases. So this is not compatible. Also, my children used to go to Union Park Elementary School. The traffic there is a nightmare. When you try to make that U-turn on Murdoch, you have to zoom across all of 50 in thick, 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 heavy traffic. And sometimes you feel like it's a little dicey if you should I go now, should I not? Should I go now, should I not? It's very dangerous. So traffic there is a nightmare. And you have residents who are opposing it. So it's not compatible. We shouldn't be filling in wetlands, and community in this opposition. It's pretty clear for me what is the right answer. Thank you.
Commissioner Scott.
Thank you, Mayor. Mr. Miklos, you made a statement, so I'm trying to understand. So Commissioner Wilson asked about, like, would you be able to adjust the buffer, and then you said it's already tight. You talked about the DOT work, right? But the statement that gave me pause for concern is that you said that it's not going to fix the issue. And so to me, it's like you're acknowledging that there's an issue. Hold, I got you. You're acknowledging that there is an issue. And so with your expertise, if what Commissioner Wilson is proposing will not fix the issue, then what will fix the issue? That's a question to you. And then to the applicant, what additional efforts have you or are you willing to make to engage with them to maybe come to a point where there is something that they would accept? Because, we have all these codes across the county that accomplish a number of things, right? And you have a number of experts and attorneys that come in and speak to what the code says and interpret it in comparison to our staff. And sometimes we're on the same page, sometimes we're not, sometimes we meet in the middle. But I think the essence of what we're doing is representing our neighbors. Yeah, we have these fancy titles, commissioners, mayors, whatever, but ultimately we are representatives of our neighbors. And whether you're a business or you're trying to build a family home, I always run in my mind, what efforts did an individual or group or entity make to be a good neighbor? There's a bunch of neighbors here. They're not happy. And so that's what I'm trying to understand. But that biggest point is like it wouldn't fix the issue. So if there is an issue, how do you fix the issue to meet in the middle?
So thank you for the question, Commissioner Scott. To be clear, my point was it wouldn't fix Commissioner Wilson's issue. I think her concern is the width of the buffer and the type of the buffer. And my point is, and I could show you if I can use this right here. So this is from 2014. You can see where DOT just ravaged this piece of property, cleared it, filled it, everything else. So that filling adjacent to the ditch area up here, which is what's connected to the econ, which is being buffered, it's already been elevated, it's already been filled, all native vegetation was removed from that area. Some opportunistic vegetation has come in, so providing an extra 50 feet in there at this point doesn't accomplish anything from an ecological standpoint. I'm not an engineer, I won't speak to flood or stormwater conveyance, but from an ecological standpoint, there's no additional benefit to providing an extra 25, 50 feet, whatever in that area. I know that part of what the county has strived to do with the new wetland ordinance and the increase in buffers is to help at least address flooding concerns in certain areas. I think, as you know, I've not agreed with that position in the new rule. I don't think it's appropriate the way it's been codified that way. But to that end, again, I understand Commissioner Wilson's point because the Econ Code and the Wekiva Code have not been updated to address the buffer width. I don't see any difference in any width of buffer in this particular area because of what has happened to this site already and because of the type of system that it is. It's an open channel.
And then to the applicant, I heard maybe one, maybe two of the neighbors talk about the continuance. I heard some folks say their denial. Can you share with me what efforts you made to engage the neighbors and what, if any, additional efforts you're willing to engage with the neighbors?
Sure. At this point, we have only had the community meeting. Of course, they had our information and are able to reach out to us. I believe the transportation consultant has had some discussions with one of the neighbor regarding some transportation concerns. But certainly, since this is transmittal, it will have to come back. If we are lucky enough to have you vote to transmit it to the state, it will have to come back for adoption. And at that same time, the PD rezoning would be before you. So between transmittal and adoption, we can certainly engage with the neighbors and see if there's any other changes that we can possibly make to the land use plan to help alleviate any of their concerns. I do want to point out again, I understand the height concerns. However, again, it does have C2 zoning, which does allow a 50-foot building height. It is reduced down to 35 feet if you are within 100 feet of residential. I understand that. However, we did make an effort in designing the site to have the buildings towards the center of the site with the parking on the periphery, and we do have buffers and setbacks. And of course, to the south, even though it is zoned residential, there is an FDOT pond that does buffer the site.
And my last question, and you might not be able to answer this because I know it requires probably skilled expertise, but was there ever conversation about reducing the height at all? And I mean, was it feasible or just, did that ever happen? Would you guys consider reducing the height or?
I think there were discussions on what height could be supported, but ultimately I would have to leave that question, or I'll defer that question to the developer, because I think it's all dependent upon their pro forma and how it pencils out. So I can defer that question to him, if you would like him to answer that.
Sure. What's your expertise again? I'm sorry.
I'm a principal planner with Pape Dawson, yes.
Okay.
Hey, good afternoon, Commissioners. My name is Robert Moss. I'm a development manager with Eastwind Development. I live at 11959 Delphina Lane, Orlando, Florida, 32827. To answer your question, Commissioner, we're trying to build we'd like to build 4-story apartments, and based on that elevation, it would require us to ask for a waiver for up to 55 feet.
Go ahead, finish. I'm listening.
Yeah, so that's, I guess, just.
No, but the question that I was asking was like, obviously, you're a business. You're in business to make money, grow your business, provide for your families. I get that. Was there a conversation about, hey, can we do this at 3 stories or 2 stories? I mean, was there ever a conversation internally? I mean, and share what you're comfortable with. I understand business.
No, of course. No, it's understandable. And yes, we've looked at everything. We've actually tried to develop this site for over 3 years now, because we think it's a great infill location that provides housing to the local employers. I mean, not to digress from your question, but there hasn't been a new project in this sub-market area since 2023 that's been over 100 units in a market rate apartment complex. And you have a lot of employers for that, young professional age group. If you look at, you have the Central Florida Research Parkway, there's 9,500 jobs there. You have the Quadrangle Business Park. You have Advent Health Hospital just to the west, and you have Lockheed Martin, which is just down the road on Rouse. And so there's a need for housing in this area, and our goal and what we would like to help the community is to provide housing for the community, because by bringing more housing into an area, you actually effectively lower the rents because it increases the supply. So that's kind of.
No, I appreciate that. I don't have a question, but just some thoughts for you to consider for this project and others. Okay. There's absolutely a need to bring housing of all types, even different types, tiny homes, apartments, and different things like that. But that need cannot exceed our desire and our mandate of sorts to protect our residents from challenges in the future, whether it's a strong rain event or a hurricane. I represent Orla Vista, and they were flooded, 6 and 8 feet of water. And one of the things that sticks with me often is like, if the county would have said something or did something, at least we could have saved our memories. They can replace homes. Okay. And so these individuals that I see in the audience, they wear a couple of different faces for me. While they can't vote for me because we're single-member districts, they do pay my salary. And I see my neighbors, I see my grandma, my grandpa, my uncles, aunts. And so they're our bosses. And so we always have to counterbalance what our code says, what you as a property owner have in rights and entitlements, and what they want. And I always, more often than not, will lead to my neighbors. Because, like they said, they are our boss. They give us our charge. Our power only comes from them, and they've come in mass to kind of, represent their position, and they don't have the benefit of planners or attorneys, and I'm sure some of them have taken time out of their work. They could be watching TV, preparing for their grandkids or family members, and so it's, at least for me, it's this commissioner, it's always going to be what's the difference maker in you as someone who's trying to be a good neighbor and join an existing community. What are you doing to say, I'm going to be a good neighbor in a good part of this community? So it's not, a favorable or before or against your project, but I'm just saying, at the end of the day, you're trying to be a neighbor. Even if it's a short-term neighbor, you built the property, you go off and somebody else manages it, you're still going to be a neighbor for a period of time. Of course. And so the focus, while she says, oh, the code says this, what do the people say? In some instances, I feel like the conversation should start with the people before it starts with the plans. Does that make sense?
No, of course, absolutely. And I think, we had I thought we had a good community meeting, and we stayed after to address some of your questions. And I think we acknowledged some of their concerns, and because we are cognizant of that. And I think our design how we put the buildings in the middle. And we have a very big building setback. I don't know the specifics offhand, but we have a big building setback from the property
I've seen the
owners.
plans. I know what
Yeah,
you're talking
and,
about, yeah.
And so I thought we did a nice job about that, but yeah, we can definitely have further discussions with the community to see what we can do. But like Rebecca said, this is just the transmittal hearing. And so we still have time, I believe, to kind of have those discussions with the community to make sure that everyone's happy with the project.
So what happens if they're not?
Well, I'm not too sure, to be honest.
Okay. Well, like I said, that needs to be a priority for you and your team to include, hey, what is the threshold financially we're willing to risk? I know it's a profit. You got numbers.
Mm-hmm.
And so if you go to 3 stories or 2 stories, that's a hard cost for you. You know,
Right.
I don't know all that. You do.
Mm-hmm. Yeah.
And so that needs to be a conversation you have with you and your business partners or whatever before you talk with them, because maybe you can, maybe you can't. I understand either way, but like there's a lot of folks sitting here that are not in favor of us even moving this forward. So I'm not sure what's going to happen with the vote. And I generally don't tell folks. I had a good mentor that tells me don't discuss your vote until it's time to vote. But just wanted to give you those thoughts to think on.
Okay. Yeah,
Thank
I
you, Mayor.
appreciate that feedback.
All right.
Oh, sorry.
I'm going to move us along.
Okay.
Commissioner Gomez-Cadero is the commissioner of record, and she does have a motion, so I'm going to go to her.
Thank you, Mayor. So, hello? Okay. So I want to say thank you to all my residents and my neighbors that are here. Thank you for attending the community meeting and for coming here as well. And thank you to all my colleagues for all your concerns and questions and so, but I have several things that I still have to get through. Jason, thank you, but I have to tell you that you said 5 in opposition. I have 15 emails from my residents opposing to this, but not as opposing. We're going to talk about that right now. I have a question to Alberto. Alberto, are you here? Are you yeah. Can you please come? Commissioner Semrat, she brought, the question or a concern of not being compatible. Can you explain a little bit and clarify to us, since she brought it up? Please, thank you.
Good afternoon, Mayor, Commissioners.
Good afternoon.
So compatibility has to do with the relationship of the proposed development program to the existing abutting neighborhood. And it has to do with the amount of units that are being proposed with this particular application in relationship to the character that at the end of this process, the built environment will propose. So that's the compatibility aspect of it. You have a particular application today in front of you that is requesting a change of the existing future land use to something that is non-existing. So for that purpose, we put in perspective all of the policies that are part of the comprehensive plan, as well as the proposed rezoning, which is part of this application as well.
Okay, so it's compatible or no?
So the compatibility measure comes with everything related to the code standards that will be applicable after the future land use designation passes through transmittal.
Okay.
And that is setbacks, anything that may relate to that particular application in terms of the change in the height of the building.
Mm-hmm.
I know you didn't want to speak on Vision 2050, but Vision 2050 and Orange Code as a model and as a formula, they check and balances each other. There are transitional components in terms of the overall density and how it transitions down into abutting single-family residential neighborhood conditions, which in this particular case, that can be part of the application if you decide to transmit this to the state.
Commissioner, if I may jump in as well. Staff is not making a recommendation or has not provided an opinion on consistency. And ultimately, that's not the request before the board today. The request before the board would be transmittal to the state. the compatibility determination and finding ultimately would come back at the adoption public hearing when we've got a PD and an associated
Yeah, I know,
development plan
but
standards
the
to
commissioner
accompany that.
said it, so I wanted to clarify it. So, you know, it doesn't matter if it's transmitted or whatever. The people are here, and she mentioned it, and I want it to be clarified. Okay, thank you anyway, John. Okay, so thank you, Alberto.
You're welcome.
So my other thing is, Commissioner Scott mentioned about the, you know, if there were any lack of engagement with the residents, and it's true, what the the developer attorney said, the first day that you saw them was on the community meeting on January 14th. No other communication or contact or anything. Okay, so saying this because I want to provide my residents more clarification and I want all these questions to be answered, I'm going to continue this. I'm not going to deny it, I'm going to continue it so that way every question that you have is answered in this next community meeting. Is that good for you all? Yes? Thank you to my residents, thank you. So I motion to continue this for, when is the date?
Commissioner, that may depend on your availability for a community meeting and then ultimately coming back to the board.
That's why
So,
you always give us like, I don't know, 1 month or.
Yeah, I can certainly look at the upcoming agenda and give you a few date options.
Yes,
Just a
please.
second.
So we need to try to come up with a date to continue it to.
Commissioner, we have, obviously, we talked about the dates in April already, April 7th and April 21st. And then following that would be May 5th and May 19th. So it depends on the applicant's ability to be able to provide some information for clarity to the residents, and of course,
Yes.
your schedule.
And the community meeting, and then I think the May 5th would be good because we have enough time to have everything. So that's good? Developers?
Applicant team, are you good
Applicant?
with early May, late May?
Early, late?
Sorry, Carolyn Haslam with Ackerman, 420 South Orange Avenue. So just to clarify, we're going to try to continue date certain to be able to fit the community meeting in that, correct?
Correct.
Is that what we're looking at today?
That's what I believe, yes.
Okay, so I think we need at least 30 days for them to send out the notices and us to prepare and whatnot, so May would be sufficient, yeah.
Which date in May?
Okay, so, but May to come back here?
Yes.
So in the
It has
meantime,
enough.
we can do the community meeting and you are prepared? Okay, so
Yes.
May 5th, it will be okay.
Good.
Got it?
Yeah.
So I
Yes.
motion to continue to May 5th at 2 p.m.
All right, all in favor, let it be known by saying aye.
Aye.
Opposed, no.
No.
All right, the motion passes 5-1. All right, thank you all. We'll see you back on May the 5th in the afternoon. With that, I think that was the final item of today. Yes. So with nothing else, thank you all for your patience. It kind of went a little long this afternoon, but we stand adjourned.